I may be pardoned, my lord. In this, all the three cases, where file the counter online, we are also serve the copy, and this hard copy we have. Other cases, we don't have receive an instruction whether this counter is required to file or the same counter will be adopted for the same. That restriction I don't have, ma'am.
Should we proceed?
Lordships, I've gone through the counter. It's only on the point of law, so I think
Tinta cases.
your Lordships may kindly take the second sub-item.
Yes, madam.
Lordship, the second sub-item, WPC 39868. Your Lordships,
Yes.
In that case, we didn't file the counter.
same thing, same pleading, everything.
According to him, it is same thing, but we don't have any
Same
instruction.
because The one they have filed is also my case, is the same pleading. Yes, your Lordship. Your Lordships, may I take your Lordships to Annexure 6, page 52?
Yes.
Lordships. Now, this is a notification which the DMET came up, which is Director of Medical Education and Training, which looks after all the medical admissions, even paramedical and nursing in our state. Your Lordships, I'll place that notification. As per the notification of INC dated 6/4/2023, the admission to basic BSc nursing during the academic session 2023-24 shall be through common entrance exam conducted by the state government common entrance cell university instead of NEET UG. Accordingly, the selection of students for basic BSc nursing shall be done through entrance exam conducted by State Nursing Selection Committee Odisha for the academic session 2023-24. Now, your Lordships, in this notification, they did not specify anything about the management quota. Now, this becomes significant if we go to the historical background in our state.
Yes. Yes.
So, your Lordship, this notification has to be read in the historical background. Every year, your Lordships, in hundreds, new nursing institutions come up in the state. Now, the government, the institutions completely have to be filled up through the government counseling. When it comes to private institutions, 85% seats, the government makes effort to provide students from the central counseling. And the central counseling happens among the students who sit in these entrance exams. And the 15% is completely left to the management quota of the private institutions. If government cannot provide students in that 85% seats, that is again also offloaded to the management to be filled up at the management level. So government has nothing to do to filling up of those posts, those seats.
50% plus, 15% plus.
15 is as such given to us. Even that 85%, if government is
15% plus.
yes, your
Minus 85%.
yes, your Lordships. Yes. Now, your Lordships, after this, there was no clarity that what you are doing. It was understood it's a normal that counseling will be held. Then the DMET comes up with its advertisement, the proper detailed advertisement, which your Lordships will find under Annexure 9, starts at page 55. Page 55, Annexure 9.
Yes.
And your Lordships, I'll take to the relevant page will be page 56, clause 5. I shall place it.
Yes.
The counseling and admission shall be done centrally by the State Nursing Selection Committee for all the seats of government institution and 85% of the seats of government recognized private institutions. If any seats from the 85% remain unfilled during the central counseling, it shall be deemed to be surrendered to the respective private institutions. The private institutions shall fill up the 15% of management seats and balance seats deemed to be surrendered by them by the cutoff date for such admissions. Lordship, look at page 58.
What is the cutoff date?
Your Lordships, that's been greatly compromised in our state. That's also one issue. No cutoff
Despite
date.
Supreme Court decision.
Yes, Your Lordships. Our admissions unfortunately started in the month of December. And I think only the state bodies can answer that why we have been put to this situation. Like this, it's 23, 24. Classes have not begun. Your Lordships, the only thing that we had to satisfy when we take the students is given under page 58, clause C. So we could not compromise with the basic qualifications like +2 science. It has to PCB. Page 58. Clause C. Did your Lordships get it?
Yes.
Yes. So only first one is about the age. Second one is about the +2 science. The third one is about the options that you should have in the +2 physics, chemistry, biology. Fourth one is about the minimum marks that you have to keep. Fifth one was about having ODIA. Sixth one is about domicile, but only applicable to those posts which the government fills up. The candidate must be a domicile permanent resident native of Odisha, but currently residing outside only for the government institutions and 85% government quota seats in private institution. Both female, male are eligible. So when it is surrendered to the management, we get students from various villages and even from surrounding states. We get that discretion. Then your Lordship, the relevant page would be page 69, clause 1.
Yes.
The private institution will fill up the vacant 85% government quota seats from common merit list following eligibility criteria of the admission process. So first thing that I have to do is take from the common merit list. If still vacancy remains, then rest vacant seats may be filled up at their own level by following the eligibility criteria as fixed by the state government, which was the earlier page Lordships I showed. In this prospectus, there was a clause that how the entrance test will be conducted. But in this given scenario, it was understood that was only for those compulsory government posts, government institutions, and that 85%. So once the government cannot provide from that, it is understood that we get the discretion to take it from other places. And that was going on also. And there was a High Court order to that extent also earlier. But then what happens
No,
is,
but the common entrance examination was still required.
Your Lordship, earlier it
Even
was
to fill
not.
up- Even to fill up those 15%.
Your Lordship, that's exactly what has happened is it was never insisted upon. And in fact, the way it was worded, initially, it was never insisted. Subsequently, they came up with a notification in the month of June. That's where they come with the clarification. And that is what I wanted to show your Lordships.
No, just let's go back to page 52.
To that annexure 6.
Then again to
That would be page 52. Annexure 6 is page 52.
Page 52.
That's the first
That
notification.
we have fixed. Now come to page 55.
55.
Clause 5. So, but is this your case? That for 15% of seats and leftover seats, without any common entrance test, you can admit this.
Lordships. And we
Is it
had been,
okay?
yes, and we had been doing so also.
But is it permissible?
Your Lordships, because actually, if logically seen, if the people were there, students were there, they anyway would have been
When
sponsored.
law is there, logic will not apply, madam.
I absolutely agree. But your Lordships, that's exactly what happened. And there's this order of our court also was supporting that position. In fact, because why I'm saying so, the next annexure, which is 10, even they understood the position that way. That is why they issued annexure 10, much after the advertisement.
And it should tell him,
Page 87.
yes,
This comes in the month of June. As per the notification issued by INC on dated 8/6/2023, all students of basic BSc nursing shall be admitted only if they qualify in the entrance exam conducted by the State Nursing Committee, Odisha. If any candidate will not qualify the entrance exam, then the concerned candidate shall not be allowed to take admission to post basic BSc science nursing course for the academic session 2023-24 in government counseling or management quota. So this is where they come up for the first time. So till that time,
you are challenging.
yes, your Lordships, we are.
Yes.
And your Lordships, what they did is,
Yes.
in following annexure, your Lordships will find they only allowed those students who have 50% in that exam to be qualified. And that your evidence, your Lordships will find at page 90. That's the last student which has taken. She's got 50%. He or she's got 50%.
Yes.
But meanwhile, your Lordships, what the nursing council did,
Annexure?
that would be annexure 11. Relevant page would be page 90. That's the last student. And the mark secured is 50%.
No, we could not get that.
Annexure 11 starts at page 88.
Yeah.
And your Lordships will go to page 90. There is a table there.
Yes, 50 for the open.
Yes. So 50% was the last. This is the last student
For open.
for all your Lordships. And that's the below anybody securing below 50 has not been declared as qualified.
So 50% is the qualifying mark.
Mark they have kept of the entrance exam.
55 marks, 50 for qualifying.
Yes. But meanwhile, the INC did away with this qualifying. Totally did away, which they have also admitted in the counter.
Where is that?
That will be following pages, your Lordships. Starts as annexure 12 series. Page 91.
So is this the stand of the state government that 50% is the qualifying mark?
Yes,
Specific.
specific. But INC has done away with it and also admitted the same in the counter. Page 91. This was, your Lordships, many institutions from various states were sending clarifications and they have answered it. Page 91, the second paragraph.
No, but was there any percentile criteria?
INC did not provide for that, but DMET had provided
No. DMET provides percentage,
percentage.
but here there is reference to percentile.
That's exactly what they meant. That's the meaning that, you
Oh,
you only have to sit for the exam. They've clarified it. That you only have to sit. You may get a 0 also, but you only have to sit. I mean, that's how they've clarified it in the counter. And Your Lordships, not only this, there are series of clarification that they have sent. Starting from up to page 93.
in 93.
Yes. In 92 also there is a clarification, the similar line. Even page 93, there is a clarification, the similar line. 93 is to the state of Andhra Pradesh. Then to there is, the first one was to Punjab, to institution in Punjab, then was to Chhattisgarh, and then it was to Andhra Pradesh.
Yes.
Yes, Your Lordships, now I want to refer to another annexure, which is of the INC, based on which the annexure 10 was passed, which Your Lordships will find under annexure 7. That would be page 53. The annexure 10 is based on annexure 7. Page 53, Your Lordships. May I place it, Your Lordships?
Yes.
This is in continuation of the notification number 5 of 2023, by file number so-and-so dated 6th April 2023. It is clarified that all students of BSc Nursing shall be admitted only if they qualify in the entrance exam conducted by the state government university state common entrance cell. Now, the next portion is the logic. In case the admissions are resorted to without the concerned student not passing or appearing in the combined admissions test conducted for the purpose of admission to BSc nursing course, nor following the guidelines for admissions prescribed by the INC, all students will be liable to face problems in reciprocal registrations. Now, here, if Your Lordships would permit, I would explain. Reciprocal registration is, suppose I am a nurse registered here. If I go and practice, say, in Punjab, I would be entitled to have registration there. Unfortunately, Your Lordship, I think DMET will clarify that also. In state of Odisha, only the government institutions and some very good private institutions like KIMS, Ashwani in Cuttack, have their seats recognized by INC. So as such, in state of Odisha, the major bulk of private students coming out do not get a chance even to practice in other states. Either you do it in Odisha or you don't do it in anywhere. So these are as such not. So reciprocal is a problem which will not arise for a major of the private institutions. I think to that extent, DMET can clarify that. So the logic here that INC gave is that it's not that you cannot study BSc, but you will have a problem when you want to migrate to other state. So that was all the logic which INC gave here, and further relaxed the entire percentage. So if you are giving a 0, And if this is the situation, and it comes midway also, because for last so many years, we have been taking students who do not sit for these exams. This was not even popularly known to anybody. So now the situation is this, that only 10,000 some students really sat for this exam. Now that statistics the DMAT has produced in its own counter. So I'll just take your Lordship, the whole picture becomes clear thereafter. In the DMAT counter, your Lordships, Lordships, it will probably be there in the in this very brief, starts from running page 481. Running page 481.
Counter affidavit on behalf of?
It's by
Okay.
Sachidananda Mahanti, opposite party number 2, 3, and
Yeah.
4.
Yeah.
That starts at running page 481.
Yes.
Lordships, they have given their statistics. First, your Lordships, see page 511. And next, just C by 2. Did your Lordships get it?
Yes.
Yes. Your Lordships, number of applicants applied for the course is 12,035. The first data.
Yes.
And then number of applicants who appeared for the exam was 10,943. Number of applicants who cleared the entrance exam is 10,097 based on that 50% mark. And then your Lordships may turn to page 527, G by 2. So out of that common entrance exam and government counseling, this is the statistics which comes out. This is all that the government has been able to provide. Total number of students taken admission is 3,680. Total number of students taken admission in government institutions is 730. And number of students taken admission in private institutions is 2,950. The following page, your Lordships, shows the vacancy now. Total seats available in private colleges are 13,493. So the students who were qualified were much less than the seats that we have today in the private institutions. And the number of students taken admission in private institutions are 2,950. And the number of seats which are vacant today is 10,543. So out of the 13,000 seats that we have in the state of Odisha, only some 10,000 people at all qualified based on that 50%. And even after you sponsored them, today we have 10,000 seats. And every year, 100 of nursing institutions are allowed to come up. We pay a huge amount of registration fees. And it will become very difficult for us to even run the institution if you have so much of vacancy, even for the existing students. So that's the position. Now, INC in its counter has taken 2 grounds. It says that we are only insisting if you sit for the exam. But then I don't find the entire objective behind this. When you're making it 0, you're asking to sit for the exam. And if your only logic is reciprocity, then probably it does not apply a little to the state of Odisha because of the situation it prevails here. That's one aspect. The second aspect that they have said is that this is becoming an infructuous matter because there was a deadline which was set and you have all made admissions beyond that deadline. In fact, the government colleges also have had admissions this year beyond deadline. But for that, we are not responsible. Now the DMET has started its admission process in December.
No, but for extending that deadline, you may have to approach the Supreme Court. Because the Supreme Court says that you cannot cross it.
Because DMET knows about it. We've been insisting on that.
Even then, it is in your interest.
I
Because
agree.
the deadline which has been fixed by the Supreme Court cannot be extended by anyone. If the state government is doing it, they are doing it at their own peril. And
Even the entire government institution today, all the admissions which have taken place, in that case is also invalid, Your Lordships. I can only, yes.
this
Mess.
proceeding, if we look the entire thing from that perspective, then this may be
I do realize that
a
difference.
kind of public interest litigation.
Your Lordship,
But
in fact,
what relief can you get? is
we
the
have
question.
also, in fact, that's the reason why we were aware that this is going to come. If that is the reason why we, in our very petition, we had already pointed this out. And we've been pointing this out in various petitions also, because the DMET takes a huge lot of time also to even provide the minimum affiliation every year. And we've been telling this, that if you delay everything, so you will land up in a situation where we can't wriggle out. So today then we'll not have a valid student for the entire 2023-24, irrespective of the institution, irrespective whether the student sat for their exam or not. Legally, I can't battle that position. Legally, I'm very aware of it.
We appreciate that.
Legally, I cannot battle that position. But a huge litigation, we are continuously pursuing the DMET that do not take the students to this situation. Today, if nothing else, in these big nursing institutions attached to these big medical colleges, where you have these 700 students, even they would be invalid. This is the situation definitely has been created. And every year you are giving facilities to create more and more seats.
May I pray, my lord?
And,
Just
and,
let her conclude.
and what is happening is, this particular change that DMET wanted did not make it popular also throughout state of Odisha. There are many science students going down to the villages. Science is a popular subject today. Everybody wants to do science. They did not know that suddenly these changes are coming up. So they were like, okay, even if we don't get through, we don't sit. But we have this management quota. And Your Lordships, is also another thing. You are making it zero. You yourself are also stating that I'm not able to provide you students from the common. It is understood that it will be outside that common entrance. Because once you can't provide, how will we go and get students who have sat for their exam? That means they're basically not interested. Because there are many other paramedical courses also. Somebody might have gone for physiotherapy. So even that 10,000 students may not be only nursing students. So they knew it well. The position was understood. So I think there's a sudden change. That is also a sudden change to which nobody could adjust. So that's all that I will rest my case, Your Lordships.
What I am submitting, my lord, two things is before my lord. One,
Can you give us that decision? I've forgotten. The Supreme Court's decisions.
we have annexed in our Allah counter.
You have
Proceed,
annexed.
Counsel
Yeah,
has annexed it.
As well as your annexed this judgment of this Delhi High Court also. And here what happened, my lord, many of the pharmacist institutions come forward before the court that even though it is not permissible, they are not minimum standard, they are opening the nursing school on their own way. Then they are crying before the court that because the state is going back, this INC is not giving permission, that's why students are not getting admission. So-
See,
Ji.
whenever any authority grants permission to establish a college, that authority has also a duty to see whether there is requirement of such institution
Exactly, madam.
based on the availability of the aspirants, or so there are so many factors. We are not here to work out those factors, but it is your responsibility also, the responsibility of the state also, while granting recognition. There must be, I believe, some provision under the
Yes, ma'am. There is a regulation is
what
there.
that before granting approval or before granting recognition or whatever term you use, they are required to be satisfied that there is any such institution in the vicinity, there is a requirement of such institution or not. So these are factors which are also taken into account while granting or refusing
Yeah.
the approval.
May I pray, my lord? Can it be day after tomorrow? Then other case we have not, we are ready to adopt this counter, we have filed in other
There is
cases.
nothing in this. There is
Yes. So let's say, keep
no
it to day after.
requirement of any counter affidavit. And she has
Yes,
been very,
but unless until this council is, INC will not.
she has been very fair in the
We-
stand which she has taken. She knows the weakness of her case also, and the logic which she has
Explain, my lord. Yes.
attempted to explain.
Yes.
So, order passed by this High Court.
Yes, the last
My lord,
order is there. Last
Only
order
one
is
thing
there.
is that without a student will appear in the examination, he cannot apply who is come to
480.
outside and take the admission.
480,
That
your
is,
lordships.
we have
Of my
some other
brief.
way.
Just
So such situation did arise. The court had addressed it. 480, Annexure 16.
Nexus 16,
16.
same situation also at the time of prospectus being released.
Yes, your lordships. We had the same problem. I'll place that.
So the clarification later on it has come.
Yes, your lordship. So this was the prevailing situation.
no, but this judgment was rendered in 2016.
Yes, your lordships. It was.
And the Supreme Court's decision is subsequent to this.
Subsequent, and but the problem is,
May I-
last year
may I be
also, they
permitted-
followed the same standard. The problem is that this regulation also of that examination, everything was there. That order was also there last year.
May I
But
please
still,
be-
they have continued with this position.
Yes.
My lord, the prospectus, my lord senior has not mentioned. In the prospectus itself, there is entrance examination, that's page 72. And that entrance exam that says it should be 50% of marks. In 2021, the INC made a regulation wherein it was for the first time specifically made, there should be entrance examination to the admission to the BSc courses.
So are you following everything what the INC you are for the INC,
No, I am for the DMT, my lord.
DMT.
Yes, my lord.
So you follow everything what INC asks you to
Yes,
do.
but the only thing, the problem this year, because my lord, due to COVID and all that for last 1 year, there was delay in admission due to COVID problems. There is 1 year problem. That's why this year also, there were a lot of petitions were filed before this honorable court. There was a lot of direction for giving NOC, for which it was delayed and a lot of petition has come. Up to last year, there was GIS mapping was there. So accordingly, we were restricted to the institutions in the areas. But this year, there was no GIS mapping was there. That's why a lot of institutions came out. And due to the order of this honorable court, we had extended NOC and till date also we have also extended, though we have.
So you are blaming the High Court?
No, my lord, no, my lord. That I cannot. Because when there is some direction, we accept also that to consider their case. Because that is the reality of the situation. And what happened, my lord, as it was been suggested that in the entrance examination, the notice what she has selected, this notice of conducting the examination was in continuation to the prospectus entrance examination. Because there was entrance examination in the prospectus, we notified when the examination has to be done. And the examination
All
was,
right. So
Yes.
when was that notified, the examination?
examination is, she has given that. Is,
March 2023.
Give the date.
that is 19/6/2023.
19/6/2023 for the academic session
23-24.
23-24.
Yes, ma'am.
So you came out with this advertisement or notice
Yes,
for
ma'am.
examination.
Yes, ma'am.
When was the examination held?
I have given in my, I have got a date chart, my lord. I have given everything in that.
So when was?
I'm
Let's
placing.
just understand. Have the feel of
I am giving my lord.
the dispute.
The difficulty is, brother,
Yes.
My lord,
So
On 31st
19/6/2023 was your admission notice.
Yes, ma'am.
Notice for examination.
Yes, my lord. The entrance
Page
examination was,
87 and etc. 10.
yes, ma'am. And,
Yeah.
and 31st August 2023, my lord, entrance test was conducted.
Entrance test conducted. When
Yes.
did you take admission?
My lord, the result was published on 15th of September.
15th of September.
Yes, ma'am.
And by what date did you allow admission?
INC fixed the last date on 30th September.
You fixed 30th September.
Yes. Again, it was basically on their request, it is extended to November. So, but after Supreme Court judgment, it cannot be extended. This judgment we have cited in our other counters. So,
Beyond which date? What is the cutoff?
yes,
What is the cutoff?
cutoff date was ultimately that is 30th September 2023.
No. What is the cutoff?
Cutoff date was fixed in November.
Supreme Court.
Yes,
30th November 2000.
30th November 2023.
Supreme Court says
Yes.
30th of November.
Yes, ma'am.
Last date of fix has been 31st 11 2023. 30th 11 November 2020. For the academic session 23-24.
Yes.
My lord,
So who will submit what? Who is going to submit what? She has completed her submissions.
Yes,
What
sir.
is your stand?
my stand is, my lord, I am giving a date chart, my lord. So we have, our stand is that we have conducted the entrance examination, and as per the conducted examination, as per the result of the examination, this admission should be done. Regarding the cutoff date fixed by Supreme Court, I have not mentioned anything wrongly. I may give another additional affidavit to that extent, my lord. Because we wrote a letter to
Have
INC.
you allowed admission beyond November 2023?
Yes, my lord, as the record says, I have seen. That shows that we have allowed.
So
And
you
we have given permission up to 29th of February for uploading their names of the private institutions, which is, I admit, also it's a mistake. Supreme Court's order we should not have, because we came to know on 24th of January when we wrote to INC for extension and giving 0 percentile. They gave us that they cannot allow the 0 percentile, and they have given the judgment, which I have received.
No, what is 0 percentile? Why are you confusing between two expressions, percentage and
No, my
percentile?
lord, because these candidate, this institution give their applications for 0 percentile, and they have got the records on the INC that 0 percentile. That's we wrote to INC whether this can be done in our space.
Mister, there is difference between percentage and percentile.
Yes, my lord. Yes, my lord. That also I know.
So we have not been able to understand why this expression has been used in
In our state, my lord, what happened? 50% was the cutoff mark, but a lot of people didn't qualify actually, my lord. So we got the representation. We gave them 15% extra marks. By that, this result has come. We have got a lot of students now qualified.
So where from you get that?
My lord.
50%? Where did you get that 50% or 15%?
15% aggregate mark we gave after considering the
From where?
But it is no.
So you would have added 50%.
Some questions they said that it was all mistakes. That's why we give 15 marks to each and all candidates to get better number of students to get admission. That is the
Very sad state of affairs.
How can you say that Supreme Court judgment was?
to my lord.
Please don't take this plea ever.
My lord, the day before yesterday, I asked them why you have done all these things. They didn't answer. They told me that we have got this letter. That is their mistake. They should have gone to the Supreme Court directions and all that.
May
That was the
I-
mistake.
You
I told
cannot,
them.
my
My lord, I have told them also.
we are rather surprised to know that you are taking this plea that DMET did not have any knowledge about the Supreme Court's decision.
No, my lord, I told
DMET should
them.
be run by something else, some
Then my lord, I told them also.
other body.
As a Supreme Court direction is there, any admission done after the cut-off date cannot be accepted by any court.
Then
I have told them.
Any
and
court
we have
of law-
consequence.
where is the question of court of law? That any authority
Yes, my lord, that cannot be taken into consideration. Their admission cannot be accepted. I have told them. This is the fate you have to face.
May I make two submissions, Your Lordship?
May I
Your
pray, my
Lordship
lord?
rightly
Just-
asked that are you sticking to everything that INC is asking? That is why, Your Lordships, I had kept annexure 5, page 51. INC had already notified that your entrance exam would be conducted on 15th June 2023. Your Lordship, that's there in annexure
Before.
5, page 51. They
Before the
gave the
15th.
notification only. And my senior just placed this, that court has been giving orders and that's why they delayed. That's not true, Your Lordships. In those batch of cases, which I myself have been conducting also, Your Lordships, they have their internal guideline as to how these NOC proceedings will happen. The time frame is there. And that time frame ranges from 1.5 years. So they get enough time to give NOC to any new colleges. They sit over the matter. They have delayed it. Like the institution who should be participating this year, the NOC should be there in December last year. They don't do anything. They sit over the money. They sit over the NOC proceedings. That's why court took note of it. They said, you have your own procedure. And now you take all the money and buy things. So, Your Lordship, that kind of a blame either on the petitioner or that the court helped us should not be taken.
No.
That's my submission.
May I permission, my lord, keep it to day after
Take your seat,
tomorrow.
madam.
I'm praying, my lord, let's make keep it to day after tomorrow. And I have a small clarification with the INC. Then I'll place it. It will be concluded on day after tomorrow.
What?
This whatever where know that this counter filed, it will be adopted here. But
There
because
is no counter required.
yes, my lord, I'm bow down to this. But situation is this: different institution have a different cause of action. So if INC have any things in this regard about extension,
No, they may, cause of actions may be different, but the outcome we know.
outcome is one. So my lord is if you dispose of it, then
Outcome,
it's
the outcome of the case we know. What
But-
we are
but
contemplating, what we are contemplating, that in the given circumstances, we shall be issuing general guidelines for all of you to follow strictly.
exactly. Yes.
Otherwise, all of you
It-
will be liable for contempt of court. So
It is
this
helpful for everybody.
this we can do for the future.
We will, my lord.
We will be laying down, if you want us to do that, we will be doing the exercise which you are required to do. We will be fixing the dates when you shall come out with the advertisement, when notice for examination.
My lord, I may be
What should be the-
permission to leave my lord, my
Everything.
associated there.
Please, please. Therefore, you were asking us to adjourn the matter for day after tomorrow. All right.
Your Lordships, can I
Yes, I am
wait because
facilitating.
Mr. Party rushed for the case where
That's it.
I am the opposite party.
All right.
My associate.
Yes, my lord, I am placing a dead set on that. Captain.
All right, we will see. Nothing else is to be argued then, huh? Judgments are there.
Yes, my lord.
Judgments have been,
Yes, yes, in,
They have an INC counter, they have given a judgment.
under Annexure 2 series, I have annexed those judgments.
all right, these matters will. Matter on the day after tomorrow. So as to enable and counsel for the INC, Indian National, sorry. I was going to say Indian National Congress. Indian Nursing Council to address this court on the nature of directions which this court should issue in the background of situation which has emerged in the emerged, as is evident from the pleadings and other materials, other relevant materials available on record in the present case relating to admission to BSc nursing courses or course
BSc nursing course.
In various private nursing institutions in the state. That's all.
Not complaint to any session. This session is.
All right. We will hear you.
Mile, mile.
All right.
Obliged.
10,
But you, all of you tell us that what order should be issued by the High Court to be followed by all the functionaries in the matter of admission.
Yes, ma'am.
Particularly nursing admission,
Yes, ma'am.
including on the point of grant of recognition,
And-
no objection,
Yes, ma'am.
those. Please address us.
Item 10, item 10, 11, 12, man. Similar.
Conference.
10 and 15.
Like senior counsel in
Second.
senior counsel for the petitioner in second item. So, the arguments advanced by her has been adopted by the learned counsel appearing in other cases also. पूरा batch जो भी है और सारा केस देख लिया हाँ understood. Sure.
May I please, Lordship? My Lord, here the petitioner is challenging the annexure 7 at running page 56. My Lord, this is case of the year 2013. I found that the matter has never admitted. I only seek only 3 days time to obtain instruction whether any cause of action survive or not. My Lord.
Let us see whether there is any chance of cause of action
Annexure 7, my Lord,
surviving yet.
page 56. Whereas the central government is of the opinion that the industrial dispute exists between the employees in relation to management of the central excise custom and service tax and their workmen in respect of the matter
Learned counsel
specified in
for the petitioner seeks and is allowed a week's time to seek instruction as to whether the cause of action survives or not, since this writ application has remained pending for nearly 11 years and has not been admitted so far. Yes.
Item number 3,
due to negligence of the content opposite party, Archaeological Survey of India, and non-implementation of the the order dated 8/12/2020, the monument as declared by the Government of India, 5th century AD, is in dilapidated condition. And no infrastructure under the National Conservation Policy, no steps are taken by them. Not a single the coin is being spent in spite of the fact that the Director General ASI has issued series of instruction to the state archaeology to take infrastructural development, my lord. So neither the boundary nor anything, any provisions under the National Conservation Policy, so it is not being carried out,
What was the direction?
my lord. So the first direction was to have the demarcation. And the last part, the superintending archaeologist opposite part number 3 to ensure protection of Ananteswar temple in the national conservation policy. So my lord, the under
But
the
nothing has
national,
been done. You have done nothing.
I will have to take instruction on this.
You are for
Madam, for the number 1 and 2.
archaeological
On
survey.
behalf of Learned DA.
You are in trouble
We'll take instruction.
as requested on behalf of the contemners. 4 weeks time is allowed for them to show cause as to why contempt proceeding be not initiated against them and they be not punished for deliberate disobedience of this court's order dated 8/12/2020. So stop. List this matter on 4 weeks. Stop. The contemners shall be at liberty to comply with the said order in the meanwhile.
okay.
We can give you more time, 6 weeks. All right.
Item number 4.
May I please? Here, my lord, the appellant has challenged the order of the honorable single judge where the writ application was dismissed with the ground that the divisional court doesn't have cannot adjudicate the disputed question of fact under section 15B of the Odisha Survey and Settlement Act. But the fact remains, my lord, the
Where is the order?
divisional, my lord, order at annexure 12, my lord.
Yes.
Order dated 28/11/2022, page 75.
Order dated?
28/11/2022, annexure 12. My lord, the order passed by the honorable single judge on a,
Let us see the.
my lord,
Provision.
This is service agreement. This is service agreement.
the scope of revision is, my lord, the revisional court is to adjudicate the dispute between the parties under
Let us see.
section 15B, my lord. And therefore, the honorable single judge has
Let
committed
us
error.
see,
My lord.
Mr. Please wait. So what was the order under challenge before the
My lord,
divisional authority?
order of the commissioner was under challenge, my lord. Annexure 10, my lord.
Commissioner under section?
Under section 15, my lord.
Section 15.
my lord.
No. The order of the commissioner was passed under which provision?
Order of the commissioner was passed under section 15B of the Survey and Settlement Act.
So he is the revisional authority.
He is the revisional authority.
So which order was under challenge before him?
The order of the settlement officer
Settlement officer under which provision?
under section 12, my lord. Under section 12A, an appeal, if presented within 30 days from the date of the orders appealed against, shall lie from an order passed by the assistant settlement officer under section 12 of the settlement officer or to any other officer specially empowered by the government in this behalf, my lord.
12?
12A.
A.
A.
And 12B has not been passed.
12B, my lord. 12B has not been passed.
Huh?
Not my lord.
12B stage has not reached.
No, my lord.
So even before 12B,
My lord.
you approach the revisional authority.
My lord, here, my lord, I have to check up because 32 is a provision where the after 12A, 32 is the provision. But the honorable single judge on the passed the order.
Let's come to section 15.
My lord, 15 is only after publication, final publication.
Therefore, we put
So
this
therefore,
section-
my lord, I am to check up, my lord, whether the final publication was there or not, my lord. Because he has filed the appeal under section 12A, my lord.
Yes.
So therefore, the appeal revision was filed under section 13, my lord. 32 of the Survey and Settlement Act, my lord.
So this order has been passed. This is under section 15B.
But the order was passed by the honorable single judge, holding that the order was passed by the commissioner under section 15B.
So, and why didn't you invoke 42? If you were aggrieved by any entry
My lord.
under section 12B, you could have challenged the proviso to subsection 1 of section 42.
My lord. My lord, 42 is there, but at the same time, 32 is also there. Any person aggrieved by the order of the settlement officer can approach the commissioner. Under section 32, my lord. The Board of Revenue may call for the record of any proceeding from whose decision no appeal lies if such officer appears to have exercised.
Therefore, under which provision you had filed your revision application?
My lord, I have to check up the revision
What
application,
check
my
up?
lord. Otherwise, my
You are
lord.
challenging that order and you are saying you will have to check up.
My lord, because on the wrong presumption that the order was passed on the section 15B, the honorable single judge has passed this order, my lord. Therefore, I am to take instruction.
Tomorrow, as requested on behalf of the matter tomorrow.
Item 5.
My lord, tomorrow.
Yes.
My lord.
Tomorrow, day after tomorrow.
Yeah.
Item 5.
My lord.
This metro was in the list, yesterday that was in the list. This
Yes.
metro was yesterday in the list, my lord. And my
Yes.
lord has said that lordship will pass a common order.
That
Government land has been
government land.
occupied by a
Do you have that
private
notice?
person, my lord.
Huh? Well, it's uploaded. Just a minute. So we have passed, issued general, have you seen that?
No, I have not seen it. You also said section invoking section 133 of the CRPC, Lords.
And the
Yes.
provisions of
OPL Act
Act.
also, Lords.
We have issued general direction.
I will get it, Lords. I will get it from the.
Just, we will make you read.
Sharing with the people. Can you share? Can you share?
Sure.
Yes, yes.
Yes.
Minimize control.
They'll just share, but you don't do anything. Don't do anything, let them do. Yes. This one, sir. Paragraph 25 contains the general direction. Please read it out.
Accordingly, we deem it proper to issue general directions to be followed by all concerned in the following terms. One, once a district magistrate or sub-divisional magistrate or any other executive magistrate specially empowered in this regard by the state government receives an information on the basis of a report of a police officer or otherwise that condition precedent for exercise of power under section Roman 1 of section 133 of the code are present, the magistrate shall at once make a conditional order for removal of obstruction or nuisance from public place, and it will be bound and duty of the person who may be a natural person or a jurisdiction person such as a municipal body or a gram panchayat to either comply with the order or appear in the proceeding, and upon appearance of the proceeding, the magistrate shall be duty bound to ask the proceeding if he wishes to deny the existence of facts leading to the conditional order and if the proceeding denies existence of any unlawful obstruction, nuisance, or any public place or from any way, river or channel which is or may be lawfully used by the public and gives reliable evidence in support of such denial, the magistrate shall stay further proceeding until a competent court decides. But if the proceeding fails to give any reliable evidence in respect of denial of the existence of the fact leading to making of conditional order, the magistrate shall order the proceeding to comply with the conditional order, and if the conditional order is not complied with and obeyed, penal consequences such as embodied in section 180 of the penal code shall follow. Then 2 minutes, it will be the duty of the chief executive officer or any other officer specifically authorized by him, head of the local body, by whatever name he may be called, to inform or cause to be informed the district magistrate, subdivisional magistrate, or any other magistrate specially empowered in this behalf by the state government as regards the existence of obstruction, nuisance, and other factors enumerated under section 133(1) of the code. The officer in charge of the concerned police station shall also have similar duty to inform the magistrate concerned under section 133 of the code. In the event any public nuisance or unlawful obstruction of the nature as provided under section 133(1) of the code is found to be existing without any information to the concerned magistrate, the officer in charge of the concerned police station and the chief executive officer or any other officer authorized on his behalf or the local body shall be jointly responsible for inaction and will be liable for disciplinary action accordingly. 3. The magistrate, upon receiving information in the manner as prescribed as aforesaid, shall proceed at once in accordance with section 133(1) of the code and pass appropriate order as required of him under the said provision. Any inaction or dereliction of duty by the magistrate in this regard shall make him liable for disciplinary action. Therefore, a conditional order, if not objected to, or an order which has been made absolute, shall have to be obeyed by all concerned, and any disobedience of the order shall attract penal provisions of section 188 of the Indian Penal Code. The Tahsildar, within the meaning of section 3C of OPL Act, shall also be duty bound to act in accordance with the provisions of the OPL Act once any case of unauthorized occupation of government property is brought to his notice. This order may be followed with utmost scruples and without any demur. Any person who is found to be not complying with the present order shall be liable for disciplinary or criminal action apart from contempt of this court.
So everyone.
Yes, Lord.
You.
Yes,
The
I'm
state
grateful.
authorities, everyone will have to follow.
So far as OPL Act is concerned, I'm grateful that there was no provision contained in that act that any person can approach so moto. Only it is the authorities, those who can initiate a proceeding so moto. Now, by virtue of this order, anybody can approach the OPL authority for initiation of action.
This writ application in the nature of public interest litigation, raising grievance relating to unauthorized encroachment upon a public land stands disposed of in terms of this court's decision rendered on so and so rendered on on 21/2/2024 in WPC number 3385 of 2024, bracketed Trinath Panda versus Commissioner cum Secretaries. Yes.
57, I may say.
57.
57.
All right.
My objection.
Item number 6.
Yes.
So I have to submit some documents. Last time it was instructed.
Documents.
Regarding the petition,
Huh?
last time it was not clear.
How will you submit that?
In regards to the claim of my RR policy,
RR.
resettlement and rehabilitation. My
So you
father's
want
body
us
was
to-
pending.
You want us to declare your title?
Sir.
What is your claim? What do you want?
I want one direction from the Honorable Court for release of by the amounts which is pending at the OP4, the special officer, resettlement and rehabilitation.
Why is he not paying?
Because my father is dead now. And my mother also.
And your
But-
brother?
But in the process of this acquisition, my father was present. And it is, his name was in the beneficiary list.
Yeah, what is the provision? Yes,
No, so now he says that as per the R&R policy, he is entitled for some cash compensation. That instruction I will take note, but last occasion also wanted to him to file certain documents, I think, with regard to, so
so documents, how can you file documents like this?
by way of an affidavit, he can file
Actually,
it.
the details of RR policy was not available because it is a 2006 policy. Now,
You
they are
have to-
including in
You have
all-
to amend your
it is the old
petition.
policy. Sir,
You have to amend your petition accordingly.
sir.
और नीचे पिक्चर ना नीचे ना बेंच पे नीचे भी ड्रेस पे नहीं
He is the opinion.
अरे what is this?
Sir, myself is the petitioner and myself is the lawyer.
He is the conducting lawyer, he is also the
Then
beneficiary.
you
lawyer.
should put off your gown.
Yes,
and
that
hat
I am
off.
saying, he should have put it up.
Not here in the courtroom. As
Sir,
a question on
actually-
behalf of the
For entrance,
petitioner, list this matter on.
it is necessary.
What is it?
We-
Entrance
don't do that.
Plain dress ରେ କରନ୍ତୁ.
entrance ବି ଦରକାର ଅନ୍ୟ କୋର୍ଟରେ ହୁଏ ମୁଁ ଆଜ୍ଞା ରାଜସ୍ଥାନ କୋର୍ଟରେ practice କରେ।
Mr. Advocate,
It
as
is not-
advocate,
sir.
as advocate, you are not appearing, you are appearing in person. So there is a
Myself,
because-
actually
there
my
is a
lawyer is
because-
not available.
हाँ,
मेरे lawyer जो है वो राजस्थान में है, अभी आया नहीं।
तो आप नहीं आते ना? You could have requested.
I have to
someone else.
complete that matter,
You cannot address the court, your case,
sir,
in the man and gown.
in plain.
Huh?
Actually, without dress, it is very difficult to enter the court.
All right. Come with your lawyer.
Item 7.
To be-
Sir.
But I am giving the translated copy of Annex 4 and 5.
Seven.
Yes.
Translated 4 and 5, your officer directed to bring that order passed by the competent authority regarding encroachment of the cremation ground by another village. They have demolished, my lord, 3 villages of one cremation ground, that is plot number 332 of Khatana 530 of village Padanpur, villagers of Godi Patna.
No, what is your grievance?
Grievance is that our cremation ground, our villagers, 3 villagers we.
So is that a public place?
Yes, it is a public place, my lord. Cremation ground, it is a public place,
Belonging to the government?
government.
Then approach the authorities.
My authority I have approached, my lord.
Approach the authority.
Then authority has passed the order, my lord, you lost it kindly see.
Yeah.
I have given annexure 6, my lord. The meeting was held. It was encroached upon another village and authority has sanctioned for doing the playground in our cremation ground, my lord. Therefore, this order was, this meeting was held on 11 a.m. on 20/12/2023 in presence of the police officers and the local administration, my lord, and the villagers, my lord. At clause 3, they have permitted the cremation shall be done at place where same has been going on, and children of Totabadi village shall play as usual in the said land, my lord. We are agreed by that, my lord. It is our cremation since time immemorial. Our forefathers, the tomb and memorials are there. They have demolished some tombs and memorials, my lord. And
Who
money
has
has
demolished?
my lord, another villagers, Totabadi.
So what can we do?
My lord, what they have done, that money has been sanctioned by the government for construction of playground in our cremation ground, my lord. that villagers Totabadi, they have a separate cremation ground. They are doing the cremation in their cremation ground. As it is our cremation ground, my lord, in
So
the,
is there any dispute between two villages?
among 4 to 5 villagers, my lord.
4 to 5 villagers.
And there is a serious law and order problem
Law
there.
and order problem, they will resolve the.
My lord, they can't, government cannot sanction, this public authority cannot permit to construct or to use it as a playground in our cremation ground, my lord.
Where is the law? Where is the law?
That is my lord.
And should the High Court enter into such controversies?
My
That
lord,
one villager has some problem with the other villager, some village has some problem with the other village.
Government cannot direct that to use it as a playground, my lord. It is our cremation ground, my lord.
So has it been proved that it's a cremation ground?
Yes, my lord.
Where?
That in the ROR.
Huh?
In the ROR it has been there.
Or then go file a suit.
When ROR is there, my lord.
You can file a suit.
My lord, whether can cremation ground can be used for any other proper purpose, my lord, I will bring the decisions.
Bring the decision.
Yes, rulings, my lord, of this honor.
And what have you done so far?
That your lordship directed me that whether cause of action is there, you file that cause of action where the public administration order is there, my lord.
Mr. The High Court, please have some, you should be kind to the institution also. If we start entering into such controversies, we shall not be in a position to resolve the real disputes.
I have not examined that, but I will examine, my lordship.
Where is the question of, even if you say that the playground is, they may deny that they are not playing?
Yeah, that it has been passed the order by the public administration, my lord.
As requested on behalf, we are not convinced. Such matters we would not like to enter into.
I'll bring the
Local controversial issues that can be resolved by the district magistrate or the commissioner. The High Court will sit over these matters.
And if they permit,
There are so many cases, Mr. Counsel. They are not in a position to resolve real disputes.
if the permit public
Unnecessary.
administration, local administration permits somebody to use our cremation ground as playground, my lord.
Then file a suit.
My lord,
Remedy is there.
well, I bring the decision. You can enter your lordship, you can entertain under Article 246.
As requested on behalf of the petitioner, list this matter on 8 weeks.
8 weeks.
Item number 8.
My lord, your lordship be kind enough, my lord. There will be a law and order problem, my lord. Your lordship keep it next week, my lord. Next week, my lord.
Sorry.
Item number 8.
May I please, Lordship?
Yes, sir.
Well, in 2015, the Union Parliament, my lord, brought about certain amendments in the MMDR Act, in the Mining and Mineral Development Regulation Act. And my lord, a provision was made in Section 9B, which is styled as District Mineral Fund.
Yes, please come again, Mr. Acharya.
My lord. Well, in 2015 amendment, the Union Parliament, my lord, introduced a new section in the MMDR Act.
Yes.
Making provision for a fund, my lord, from the minerally rich areas, my lord, called the District Mineral Fund, my lord, DMF.
District Mineral Fund.
Mineral Fund. Let that money is in fact collected from the royalty of the lessees to be spent for the purpose of socio-economic development of the affected areas, and especially those areas are Millard scheduled areas, Millard to be administered under Article 244 and etc., which is subject to the giver notarial control and all. But there are huge Millard crores of around 15,000 crores of rupees in the district mineral fund in the 3 tribal districts, mainly Sundargarh, Keonjhar, which are minerally rich. But there is also, your lordship may kindly turn to 9B, section 9B of the MMDR Act. But may I just read that provision?
No, what do you want? Let
Blood,
us stand first.
there is a procedure for spending of the money out of the district mineral fund. Blood, in 2019, the district collector of Sundargarh, who is the chairman of the district level committee, he invited a tender. Blood, that is for the purpose of establishment of 70 e-schools, this virtual classrooms. Several bidders participated. That is for 70 schools. And the particular bidder, Milord, who has been shown favor by the district administration, Milord, it was for 19 crores. 70 schools, maybe per classroom, it is 25 lakhs with 1 or 2 TVs. I'm not going into that. But that tender validity period was 5 years for establishment, maintenance, everything, Milord, software, providing software, everything. But what is the glaring irregularity committed by the district authority? But beyond these 70 schools, without inviting any public tender, he awarded contract of 622 schools worth 103 crores, Milord. That money has been siphoned. That is why I am before your lordship. Your lordship may kindly turn to the scope of the work. It was for 5 years.
No, did you inform them?
Yes, everybody will.
May I
Let me finish.
Please, let me complete.
No, he has not, because it's a public interest litigation.
All right, let him complete. That is
Section
the
8.
question which we have put already.
That's correct, Milord. So, Milord, your lordship may kindly turn to the latest and the agreements. I have been writing since 2021 when those illegal work orders were issued without inviting tender. Milord, page 136. The first letter I addressed, Milord, filed annexure 5 series, beginning from 133 to 135. Which 136. Milord, 136 6 series annexure. I have been writing to different authorities, including the Ministry of Steel and Mines. To the Honorable Chief Minister, Education Minister, I am to informing you that there are serious allegations on so and so. He is the Milord tenderer, Valuable Edutainment Private Limited, Mumbai, and Resertec, London, in their forest fire tender project of so and so, so and so. This is not the next, which one? Correct, not 9 series, 9 series, 171. No, I'm sorry, 171. Your lordship may kindly turn to 171 page.
Yes.
Let's get it, Milord. To the everybody, Milord, I have addressed, including the Honorable Chief Minister, Education Minister, Director Education, Director Orissa Computer, DM Sundargarh. But virtual classroom is a boon technology for poor students of rural areas of our country, and this is also provides access of best teaching to poor students through the use of technology. But some implementing companies are playing with government RFPs and misusing public money without delivering the requisites. Odisha government has allotted 70 schools through DMA funds to Messrs. Valuable Edutainment Private Limited, Mumbai, which is already working on 70 schools of district Sundargarh in Odisha.
So, all right.
My lord.
Though it's a public interest litigation.
My lord, it's a public
Just
interest.
a minute. Though it's a public interest litigation
My-
and the dispute is being raised in respect of some work order having been given to opposite party number 5,
Right.
for which there was no tender
No
process
tender.
initiated.
Yes.
We are issuing notice to opposite party number opposite party number 5. And we will
Opposite-
see what can be done.
My lord.
Both of-
103 crores.
Both sides be ready to have an order from this court. Issue notice to opposite party number 5. Both processes 1 week.
Okay,
The
Lord, this
notice has been issued, received. Notices have been accepted for opposite parties number 1 by
1 and 2, you also may say.
list 1 and 2
Yes. Three also, my lord.
by
Yes, sorry, four more.
Learned
Four.
AGA and
1, 2, and
1
4.
to
my lord.
4. No, Ministry Government of India.
No,
That
4
is
is
number three.
District Mineral
And
Foundation
1,
is
2,
the
and
collector.
4. 1, 2, and 4.
Four.
The the Deputy Solicitor General for India accepts notice on behalf of opposite party number 3. List this matter on rule returnable 8 weeks, list on 8 weeks.
But diplomates. But in the meantime,
5 issued notice.
but this requires an inquiry by some independent
We
agency.
will see. We will see. You will get an order on PIL. This we can assure.
Item number 9.
From 9, kindly take the next week for filing of fresh affidavit. Meeting.
First affidavit. Next week,
Yes, sir.
additional affidavit.
Okay.
Item number 13.
Yes.
It's a public interest litigation, my lord. In this case, my lord, rupees 50 lakhs has been sanctioned by the government under Amma Odisha scheme, my lord, to the Gram Panchayat under the Pattamundi APS and district of Kendrapada, my lord. Here, my lord, OP number 3 and 4 being diverted by the political influential person as going to invest in ward number 2 only, so that most of the wards are deprived of getting developmental work, my lord. So that we have filed representation before the OP number 3 and 4 by the annexure 2 that may be disposed of.
We will not direct that. You may go where you want to go.
Simple pay representation is
No,
pending.
No direction. You
Most
may
of,
go
most of the wards are
wherever
deprived
you
of-
want to go.
Annexure
The-
2. Annexure 2 may be disposed of.
Run counsel appearing on behalf of the petitioner submits that this court may dispose of the present writ application filed in the nature of public interest litigation by directing the directing whom?
OP 2 to 4.
Collector.
Opposite but now 2, 3 and
The collector
Kendrapada.
Kendrapada to dispose of his representation met on where tab? Where is the representation?
Annexure 2. Dated 19/1/2024. Annexure 2 series.
You have given representation to many authorities. You have given representation to many authorities.
Representation
Which item is this?
given
Which
to
item?
2 to 4. Annexure 2 series, that is representation to the collector, BDO and DRDA, my lord.
A representation addressed to the collector Kendrapada, Odisha for what?
For the investment of rupees 50 lakhs, my lord, to every ward under the GP Chandaneswar Gram Panchayat, my lord.
But the representation is for cancellation of the projects which has already been allotted and re-allot those projects to different lords of Gram Panchayat.
Listen, going to be invested in every ward, my lord. It should be distributed to every wards, my lord. But they are confined in only 2 number wards, my lord, being diverted by the political influential person, my lord. So that other wards are deprived of getting developmental work.
We may impose cost also.
No.
Representation dated. The representation dated 19/1/2024
Stop. The petitioner
They permitted to withdraw, my lord.
and counsel for the petitioner, after some argument, seeks permission to withdraw this writ application with a liberty to approach appropriate authority for raising the issue which he has raised in the present writ application.
Item number 16.
Yes.
This is the second contempt, my lord.
Okay.
Plus, similar matters, your lordship said yesterday granted me 6 weeks time to comply the orders, my lord.
But this is second.
Yes,
Second is serious.
yes, my lord. Same batch of cases, and I assure also in most of the cases I have got the instruction that they have now sanctioned, and these cases also be complied with within that time, my lord. 6 weeks, item 16, 17, my lord.
16 and 17.
Yes.
All right. As requested on behalf of the contemners. List these matters, list this matter on 6 weeks. All right.
That's a pensionary matter. That's a pensionary matter.
Yes, Lord. My friend was the conducting counsel in the other cases yesterday.
Yesterday
Same,
there
Lord.
was batch of cases.
Batch of
Date.
cases.
Which date? Those matters have been listed adjourned to which date?
Your lordship has stated 8 weeks after.
Any day. But
No.
Yesterday's item 56 to 60 minutes. That Lord.
What was the number you give yesterday's? What?
56 to 60.
8th April.
Identical matters, all identical.
8th April.
Yes.
10th of April.
Along with other matters. Okay. Yes.
Item number 18.
18, that batch minutes. Here it's first time minutes, they've said that not, we'll do it minutes. 6 weeks we will do it because it's a 28-day application, it can be done minutes.
Learned AGA states that this court's violation of which has been alleged in the present batch of contempt application shall be complied with within 6 weeks. So stop, list this matter on 6 weeks. Yeah.
Item 19.
What else? Huh?
Item 18 minutes.
All right.
19 also minutes, lordship grant me 6 times. This is a content minutes, payment of minutes, benefits under the minutes contractor. That will do minutes. In many cases we have done, this also will do minutes. 6 weeks time lordship grant.
As requested, on behalf of same order, 6 weeks.
Item number 20.
But you also lordship, same contempt matter, it's a school matter.
Your lordship,
Here also will get 6 weeks time I will comply.
your lordship, the state has preferred SLP and the SLP has already been dismissed.
Therefore, they will comply with the order.
Yes, your lordship.
It is stated by learned AGA representing the contemners that this court's order violation of which has been alleged in the present contempt application shall be complied with within 6 weeks. Shortlist this matter on 6 weeks.
Item number 21.
21.
Your lordship, non-compliance of order dated 28 to 2023 at page 8, para 4 minus.
Same your lordship grant me 6 weeks, same lordship benefits under the other scheme. Lord.
All right. All right.
Item number 22.
May I please, your lordship? The order dated 25/9/2023 has not been complied with. But you can find it from page 9 of my contempt.
Page 9,
Of my contempt petition,
annexure 1.
my lord.
What is the direction?
Direction what your lordship, page 22. Having regard to this direction of your trace gradation list shall be published and consequently set aside the gradation list published on 18th January 2012. Annexed to the memorandum of appeal, the respondent one shall treat the select panel of the first exception and second different in order to prepare the gradation list, Rule 97 so on.
By what time?
But time was not fixed, but
Where is the contempt then?
contempt by railway authorities.
No, where is the contempt when the time is not
Because
prescribed?
time is not with normally 3 months time is there. In the meantime, 4 months have elapsed.
Huh?
(25/9, 2023).
Not much. If no time frame has been given, then what is the time?
3 months, normally 3
No.
months. May I pray another prayer, my lord? LRC may fix a time limit so that they can comply this order, my lord.
How can we modify it?
But there is no time limit in that order.
In contempt. While sitting in contempt, can we modify the writ
So
order?
that 3 months time.
What is the direction?
Direction is to prepare the gradation list.
Read it, page paragraph 27.
My lord, having regard to the direction, the phase gradation list shall be published and consequently, we set aside the gradation list published on 18th January 2012, Annexure 11 to the Memorandum of Appeal. The respondent number 1 shall treat the select panel of the first recruitment.
Shall?
Treat. TREAT, my mother. Treat the select panel of the first recruitment exercise and the second recruitment exercise differently. And in order to prepare the gradation list, Rule 97 of the RPF Rules 90 shall strictly be followed.
Who is for the other side?
Railway, normally Central Government Council appears.
Central Government Council.
Mr. Padi appears.
Mr. Fari also.
I have also served a copy and I will serve another copy also.
There is no representation on behalf of the contemners, despite service of notice upon the Office of Learned Deputy Solicitor General for India. So stop. Place this matter on 4 weeks for the contemners to inform as to how much time will they take to implement this court's order. Right. Yes.
Item number 23.
Nay, please, Lordship. My lord, I have filed a list of date and events. May I permitted to place that date of list because the entire background is that the appellant before Lordship is a development authority. He has allotted a particular land to the respondent for construction of a medical college, medical and hospital. But he has not constructed, the land has been resumed. The Honorable Single Judge has directed that lease DT to be executed in favor of the allottee. Challenging that order, this appeal has been filed. May I place the date chart, my lord, so that the entire background can be placed? I have filed a date chart, my lord. First on 11/11/91, another 2, another 3 in the WPC, out of which this appeal arises. Agreement between both parties, advance portion of 2.60 decimal for establishing hospital was given. Lease could not be executed because government
you
has
wanted
not
to give us
passed.
something, you did not give that.
Pardon, my lord?
Date chart, you said that you are giving us date chart.
Yes, my lord. Well, that is there, my lord.
It is there.
I'm sorry, my lord, but that is
All
there.
right.
My lord. The cause list says that it is there.
It may be there. Not sure. We might have missed.
So respondent number 1 is not there.
Respond number 1.
My lord, I am appealing.
You are respondent number
Yes,
1.
my lord.
Here, have you received? Have you?
Just now, my lord, senior has given me the date chart, my lord. And in the read petition, my lord, I have also filed a date chart. If your lordship will say, my lord, I will file it. I have with me, my lord. Let my lord, senior place his case, my lord, thereafter, my lord. Place.
Let us see what is this case. Yes.
Date chart is not there in the file, my lord. Date chart is not there in the file.
Synopsis is there.
Synopsis below synopsis, date chart would be there, my lord.
List of dates and events.
Yes.
List of dates and events, my lord. Yes,
It is there.
yeah, oblige, my lord. The first on 11/11/91, you also got it, my lord?
Yes. Yes, please.
May I place that date chart, my lord?
Yes, please, please.
Yes. On 11/11/91, another 2, another 3 in the writ application, agreement between both parties, advance portion of 2.60 for establishing hospital was given. Lease could not be executed because government has not passed on title and respondent could not pay full cost at that time. Construction to be made for the purpose of land was allotted. Any violation of terms liable to be evicted and land to be resumed. Well, here I may explain further, my lord, beyond this. In the agreement, what is another 2 agreement, it has been stipulated that government has just earmarked this particular land to the development authority for its development and allotment. After allotment, I will collect the money from the allottees and pay to the government. Government will execute a lease deed in my favor. Thereafter, I will execute lease deed in the allottee that has been stipulated in the agreement itself. It has been also stipulated in the agreement at paragraph 5, page 14. Paragraph 5, page 14. The second party shall use the land for the purpose it is allotted other than hospital and research center. No other activities of the second party will be allowed even if it is written in the memorandum of association of the company, the allottee company. Then, my lord, on 17/8/92, WPC number so and so, another similar agreement and advance portion of 3.44 decimal
So
land.
what is the point involved?
Point involved with, my lord, the purpose for development of the entire area, my lord. To establish hospital, there is a need for hospital. Therefore, for the purpose of hospital, that hospital has been made. Therefore, the land has been resumed. Honorable single judge has directed that you better execute the lease deed. In the meantime, what happened? The particular area for development of which is my responsibility, 4 or 5 hospitals have already been established. Now, as per the government of India policy, my lord, the land has to be developed for a housing complex so that it can accommodate more persons. Therefore, the resumed land, for this litigation, the land is lying idle. So it is up to your lordship. As a statutory body, I am bound to comply your lordship direction. As a last resort, I filed this appeal. If your lordship is not satisfied, then land has to be executed in his favor and again given to him. Otherwise,
but unless you don't satisfy,
yes,
if you satisfy any court, then it's a matter be different.
That's true, my lord.
So what is the illegality in the order?
Illegality in the order, my lord. If your lordship will kindly turn to page 7 of the appeal, my lord. I've stated the grounds, my lord. I'm reading out the 5 grounds which I have taken. Ground number B. For that, the earlier direction of the Honorable Court in judgment dated 15/1/94, OJC number 70 of 94, to these appellants was to take steps for execution of lease deed, subject to, however, compliance of the other formalities. The other formality is the lease deed is to executed by the government. In the meantime, lease deed has already been executed by government in favor of the development till 2005. So, no, one such formality is acquiring transferable right of the land from the government on execution of lease deed, and thereafter to transfer the land to sublease or outright sale or leasehold right or license under provision prescribed under section 75, 76, 52, 50 of the Act. For the fact disclosed by paragraph 5 of the counter affidavit filed by these appellants in WBC number 1, so that quote, government executed lease deed on 23/2/2005, which RDF for the land of which 260 provision allotted to the respondent number 1 is a part. That land lease the first 2.60 decibel land allotted to the allotee is a part of that particular lease that has been granted. Lease has been granted in our favor in 2005, has been ignored without consideration. The why, as per the earlier direction, why we have not executed the lease deed, because at the time the earlier direction was there, lease deed was not executed. Similarly, the fact disclosed in the same paragraph.
Lease deed was not executed.
By government in favor of the development authority.
And therefore, the agreement could not be entered into between you and him.
An agreement has been done. Lease agreement could be entered.
Lease could not be executed.
Right.
Between you and him.
Right, my lord.
Because the government did not execute the lease in your favor.
Yes, my lord.
What was his fault?
Not his fault. In the agreement itself, it has been written in the first agreement when possession or advance possession was given. The government has given us advance possession for development. We make it plot-wise and given the advance possession to him by virtue of Annexure 2 agreement. In the agreement, it has been stipulated that title has not yet been passed from the government to us. Once the title has been passed from the government
Why did you enter into an agreement?
When
the title had not passed into you, then why did you enter into that agreement?
For giving advance position so that he can develop the land, make constructions.
So he can develop the land and subsequently you may decline to agree to execute the lease.
No.
So he rightly did not develop.
But that is being done in all
If this is the situation.
Yes, ma'am.
Then this appeal should be dismissed with cause.
There is subsequent further development in subsequent writ application.
What for subsequent? Why are you blaming the writ petitioner for not establishing the hospital?
Because he has already obtained the approved plan, he has to make constructions without making.
How could he make construction? You did not have the lease from the state government.
But by agreement, we have given handed over him in the possession.
He handed over the possession without any authority, without any right. You should have been punished.
Two my.
Yes. All right. How much?
In the second writ application, may I place there is a further writ application filed by the allotee. May I place that, man?
That is attached with this case.
No, yes. This present appeal arises out of the second writ application. What I was reading, that was the first writ application.
Forget first. There is no difference in facts in the first writ application and the second writ application.
Yes, ma'am.
How much? This is the fact. These are the facts.
One thing may I beg to submit, my lord.
Contempt is there with us.
Contempt is also there. Yes. So we are dismissing the appeal and we are initiating contempt proceeding.
May I play, my lord? Since I am a developer, I have no personal attachment for this particular property.
We understand.
Your Lordship, so please give me time, I will execute it immediately. I have no stumbling block, my lord. Only for development of the area, I was doing this. But once,
Since you have challenged the order,
yes,
we
my lord.
cannot compel you to execute this entry.
No, I do beg submit, my lord.
You do beg submit only after you either withdraw the appeal or take an order from the court. You have two options.
Withdraw the appeal, my lord, but all the same, I pray that your lordship may please to grant me some time so that I will execute. To show my bona fide, I
That
will
we will do.
release it.
That we will do.
Right. My lord, subject to
Yeah.
what I do abide by your lordship direction, but one thing I want to beg to point out, you also pointed out that he has, because I have not passed the title, he has not made any construction. But in fact, if I record says that he has made illegal construction and getting commercial use of it and obtaining rent without constructing the hospital.
So that is you are not sure about your own stand.
That is
Yes, at times you are saying that the land was allotted to him, he did not build the hospital.
Yes, my lord.
Because you could not execute this lease
Yes, my
deed,
lord.
because lease deed was not executed in your favor by the government.
Yes, my lord.
At the same time, you are saying that he made constructions over the land.
Illegal
Those constructions were
construction without constructing the hospital, he make illegal construction jupudis and collecting rent. So
Jupudi.
that we have demolished.
All right.
So your lordship kindly protect my interest is for development of the area. I will abide by your lordship direction.
You are duty bound, you don't have.
Yes, yes, obliged, man.
Yeah. Land counsel for the appellant has not been able to point out any legal infirmity in the order passed by the learned single judge, which is impugned in the present intra-court appeal, requiring this court's interference to stop. It appears to be an admitted fact that a piece of land was allotted by the appellant in favor of the respondent for construction of a hospital.
I beg your pardon, two pieces of land.
Two pieces of land.
Done together, two pieces of land.
Two pieces of land. Stop. And it is also an admitted fact that the land in question belonged to the state government, which was set aside for construction of a hospital. Stop. It is also clear from the submission which has been advanced on behalf of the appellant that the appellant could execute a lease deed in favor of the respondent only after execution of a lease deed by the government in favor of the development authority. So, the allotment was made in the year 1991 by the appellant.
Lease deed in 2005.
The lease deed by the state government was executed in favor of the development authority, bracketed the appellant, in 2005.
23 to 2005.
That is nearly 14 years
after the land was allotted to the respondent. Full stop. The stand of the development authority that there was failure on the part of the respondent to construct hospital for all these 14 years has been rightly rejected by the learned single judge. This is the fact. Yes. Because in the absence of execution of lease deed by the development authority in favor of the respondent, he could not have constructed the hospital. Full stop. The appellant declined to execute the sale deed, lease deed in favor of the respondent, mainly on the ground that he delayed construction of the hospital and made certain constructions over the land for purpose not in accordance with the one for which the same was allotted. So stop. Next, after having gone through the pleadings on record and the impugned order passed by the learned single judge requiring the appellant to execute lease deed, comma, we do not find any such infirmity requiring this court's interference in and on an intra-court appeal. This appeal is dismissed with a cost of how much? 10,000?
I beg pardon, well, I want to withdraw it, my life for the public purpose. It's not for the personal grievance, my lord.
Learned counsel appearing on behalf of the appellant, I have, after having realized the all the aspects of the matter, does not intend to press the present appeal to avoid imposition of cost. Stop. So he is not pressing to avoid the imposition of cost. Stop. This appeal is accordingly dismissed. Stop. Next. It has been, where is that contempt petition?
Contempt application is there, my lord. Here, what
Where?
was earlier disposed of, now the another contempt is pending.
So this is the second contempt.
This is the first contempt, which is your lordship's record, my lord. And another order was passed.
23 is there, 23.
4690/2001.
That is 2021.
21, sorry,
Is
sorry.
pending, my lord.
This is 46.
Contempt number 4690/2021.
Stop. It has been brought to our notice that a contempt application being contempt case 4690 of 2021 is pending for willful disobedience of the aforesaid order dated so and so passed by the learned single judge. For learned single judge, as the appellant has not so far executed the lease deed. Full stop. In the facts and circumstances of the case, as the appellant has been pursuing his remedy by filing present intra-court appeal, comma, the time for execution of sale deed, lease deed pursuant to lease deed in the light of
the order passed by the learned single judge is hereby extended to which date?
If your lordship so pleases, 2 months.
No, 2 months is long.
Any time your lordship pleases. But I have to communicate and they have to make arrangements. Give notice to them.
Contempt number 2774 of 2019, you have been granted 3 months time to comply with the earlier direction. That is in 13/11/2020. That is inclusive to this.
Yes, ma'am. Yes, ma'am.
Annexure 1
Yes, ma'am.
to this contempt petition.
Yes, ma'am. On 13/11/2020, 3 months time was granted for compliance.
So you are not complied.
No, because the writ appeal was pending, I couldn't comply. Anytime your lordship pleases, let it is enough time, my lord.
Stop. If the appellant fails to comply with the said order, comma, the appropriate action shall be taken in the said contempt case number 4690 of 2021.
While parting with the case, may I submit, madam, because for last around 40 years, I am looking after this particular development authority. Every time we are facing this problem with this advanced possession problem. This advanced possession system of giving advanced possession, and again we are facing number of litigations in the development authority. So I sincerely want some remedy of that particular principle of giving advanced possession may be deprecated, so that I will not face any further difficulties. I have all bona fides, but I am facing hundreds of litigations for this advanced possession system. I can't help because I don't have the money to pay the government for lease premium. I have to distribute it, collect it from allotment, and I can pay them. Thereafter they execute the lease it. Thereafter I execute the lease it. But this system has to be changed because honestly, hundreds of litigations are.
So let some litigation come, we will see.
But I have all bona fides. I have no personal grudge against him.
Appeal is dismissed as withdrawn, but with the modification as noted above in peculiar facts and circumstances of the present case.
Item 24.
Published.
May I please? IA number 118 of 2019 is for condonation of delay. There is 10 days delay in filing the review application. And the explanation is that the 30 days expired during the summer vacation of the courts, and it was filed only on the reopening day, as the conducting counsel was out of station during the vacation. So this is the explanation for the 10 days delay.
No, but there is no delay then. Why did you file any application for condonation?
One hour. So office is open.
Yes. So delay we are condoning?
Yes, ma'am.
Delay condone. Yes. So you are seeking review.
Of the writ appeal, my lord.
Because, my lords, here, may I fairly concede, my lords, in the guise of review, this is purely a mercy petition, because only to protect the constitutional right of the petitioner in getting the rightful pension, my lords. In short, my lords, the petitioner retired as a constable, took voluntary retirement, At the time of retirement, his last pay was 4,700. And the pension was calculated based on that last wages drawn. The petition is that he is entitled to a pay of 5,000 only, and the pension should be calculated taking 5,000 as the last pay drawn. In this regard, the Honorable single judge dismissed the writ petition, that is annexed
What is wrong in the order?
well, as technical.
One, you are seeking review of order dated 1/5/2019.
Well,
Absolutely.
well, as
Where is
the
error apparent on record?
well, as there is no error as such, there is no error apparent or error or patent error, my lord. That's why I considered
Right, very fairly,
But-
fairly.
my lords. But only on the mere technicalities, the writ petition has been dismissed. So my humble prayer is that a constitutional pension is your lordship is that pension is a constitutional right akin to Article 300A of the Constitution, my lords. Apart from Article 21.
Subject to the condition that you satisfy.
My lord, my lord.
So pension, if pension is constitutional right, then every citizen of the country cannot claim pension.
Only on the ground of delay and laches, the benefits has been, the writ petition has been dismissed and the writ appeal, the order of the single bench has been confirmed. Only on the ground that the petitioner continued to accept the wages and never objected to it till his retirement. So subsequently, he cannot say that the pay should have been recasted or revised and pension has to be calculated on the basis of recasted pay, my lords. So, my lords, in the writ appeal, my lords, lordship only
we cannot go into that. If
my lord, only for your because I am seeking indulgence of your lordship.
You cannot do that.
My lords, I know the limitations, my lords, but still.
See, you challenge the order of the learned single judge before this court. You could have challenged the order of the division bench before the higher court. But you cannot seek review.
Because I know my limitations, because only for a moment, I draw your lordship's kind attention to Annexure 1 of the writ appeal, my lords, at page 12. In 24/3/95,
writ petition or writ appeal?
Writ appeal.
There is no annexure.
Annexure 1 at page 12 of the writ appeal.
Is there any annexure? There is no annexure. Writ appeal.
Writ appeal.
Sorry.
Writ appeal. In fact, the petitioner.
This is item number 24. Yes.
Lordship finds, in fact, the petitioner on 5/4/1995 had objected to the scale of pay that was allowed to the petitioner, my lords. This is the objection. But no action was taken by the authorities on this objection. And since he is a lowly paid employee, my lords, he could not protest and continued with it and retired to voluntary retirement, my lords. This annexure could not be placed in the writ petition, my lords. That is the only mistake, bona fide mistake, for which the Honorable Single Judge held that the petitioner accepted the wages paid to him without any objection and accordingly held that he cannot raise any objection subsequently, my lords. And the writ appeal also. So that is why I considered, my lords, because this annexure was missing in the writ petition and could not pleaded that the petitioner before his retirement also objected to such a, so that resulted in the impugned order. So that is why initially said, my lords, it's only question of mercy and discretion of your lordships, my lords. So
The petitioner in this case is seeking a review of an order dated 1/5/2019, passed in WA number 240 of 2016. Top. By the said order, coordinate bench of this court dismissed the petitioner's intra-court appeal, finding no illegality in the decision of the learned single judge, which was under challenge in the said case. Full stop. The facts are admitted. Full stop. The petitioner, comma, a constable in railway protection force,
my lords,
a constable in railway protection force was reinstated in service pursuant to an order dated 13/12/1991, passed in OJC number 3761 of 1988. He subsequently sought voluntary retirement, and accordingly he retired with effect from 4/4/2007. Stop. He was paid his pensionary benefits based on last pay drawn by him. Stop. Admittedly, comma, several years after his retirement, he preferred the writ petition questioning writ petition claiming pension at higher rate on the ground that his pay was wrongly fixed, and therefore his last pay drawn also was wrongly determined. Stop. Learned, the coordinate bench of this court, the learned single judge dismissed the writ petition on the ground that the petitioner, after having accepted the pay scale, could not raise any grievance after 12 years of his retirement. Stop. The division bench in the Indra Court appeal, comma, in the aforesaid background, has declined to interfere with the order of the learned single judge. Next, learned counsel appearing on behalf of the petitioner has argued that a document which was in the nature of a representation filed by the petitioner claiming higher pay could not be brought to the notice of the learned single judge, and therefore the learned single judge took a view that the petitioner had not raised any grievance against his fixation of pay. So stop. Next. After having learned, counsel for the petitioner has further submitted that this court, considering the status of the petitioner, that is a lowly paid employee, should consider the matter sympathetically. So stop. After having perused the order under review and the materials on record, we do not find any reason to review this court's order. So stop. We do not find any error apparent on record. So stop. No other ground is available to the petitioner for review of an order. So stop. This application has no merit and is accordingly dismissed. Yes.
Item 25.
My Lord, I am appearing the first item, my Lord, in item 25 for the writ appellants. Here, my Lords, the respondent numbers 2, 3, and 4, they are not appearing, and appellants also could not find the address also. My Lords, as in the writ petition, whatever address they had filed, on that basis, writ appeal was filed. And now, the whereabouts of the respondents 2, 3, and 4, appellants could not find out. So, in other writ appeals also, they are, my Lords, parties.
My Lord,
And so far as the respondents 5 to 11, they are pro forma parties.
I'm pleased, my Lord. Permitted to make submission. Item number 1, 2, 3, 4. Sub item number 1, 2, 3, 4. I am for the item number 1. I see 2 weeks time to file counter. And 2, 3, 4, Mr. Kumareswara Mahanti is unwell. Therefore, Lordship kindly give 1 week time.
2, 3, 4.
Mr. Kumareswara Mahanti appearing. I submit on behalf of Mr. Mahanti. Since he is unwell, 2 weeks time may kindly be granted.
Where is the order?
Annexure 1, impugned judgment. Page 17 in the first item. Page 17, my lords, of the writ appeal. 1-7. Selection process was challenged by the respondents. Unsuccessful respondents. Candidates.
It's 17.
17, my lords. And page 40 is the direction, my lords, in the judgment. Para 25, my lords.
So what is wrong in the order?
My lord, the main contention, only contention of the unsuccessful candidates who filed the writ petition was that the two subject experts that have that the respondent numbers 9 and 10, my lord, 10 and 11, that they were somehow academically associated with the writ appellants, the candidates, successful candidates, and my lords, that has been very well clarified by the OPC in their counter affidavit that they recused from granting any marks in the interview. That has not been taken into
But they
consideration.
participated in the.
They did not participate. They had recused from the very well in unfair manner. The selection process was conducted, and they stated that before the starting of the interview, all the subject experts were informed that in such if such contingencies arise, then you recuse from participating in the interview for in respect of those candidates, and they're recused also.
So where are those
And-
candidates?
My lord, the candidates are the writ appellants, my lord, the successful candidates.
They are respondents.
Here, my lords, they are the appellants. They are in the writ petition, they were made opposite parties. And other candidates were also not made parties, my lord.
Before the
What happened in this case?
May submit.
Unsuccessful candidates challenge our selection without implementing us as a party. But pursuant to selection, we were selected and we joined in the respective post. Behind our back, they filed a writ petition. They faced the interview without any objection. My lord, know that once a person appeared the interview without any objection.
No, but they did not know that they are related.
But they have not made any allegations against us.
That is not the question.
My lord.
The question, see, if the process is made known to them,
Correct, my lord.
they participate,
My lord.
then they cannot turn around to say that the
Correct.
process was incorrect.
Correct, my lord.
Here the situation is different. Here they say that some of the members of the board,
Yes, my lord.
say maybe of the interview or board or whatever, they were related to the successful candidates.
My lord.
So this information they had, if you can establish that, it's a different matter. And they had the information.
But
They may not be
OPSC
having
will
that
not-
information.
But the OPSC filed the counter. In the counter, OPS has stated the person who are related to the candidates at the time of interview, they were debarred. They have not, they did not join in the board also.
My lord, page 158, your lordship may kindly refer to.
Well,
It's
sir, I'm
very
appealing-
government of the.
I'm appealing for the Public Service Commission, if I may assist your lordships. Two candidates, the two subject experts were the PhD guides of the two candidates. That was the academic relationship that they had. They recused during the interview process. However, the learned single judge was moved by the fact that they did not leave the interview room. Therefore, the learned single judge holds that there was possibility of bias. And on that ground, the selection was set aside. But they on paper, they have recused. We had produced the records before the learned single judge as well, that they have recused.
That they could have done even from the outside the room. Influence can be, it's very difficult to stop influences.
So, no.
It's gonna happen. They were supervisors only.
My lord,
And
my lord, in interview board.
very difficult.
They are not related.
No, not
they
not
are not related.
And out of
Sir, in every recruitment, in academic field, this is bound to happen.
confidential.
It is very confidential. Nobody can know. See, when the person will recuse, the moment he knows, the moment he knows that, oh, this candidate has come. Now he was mine. Or if the candidate will also know when the interview is going on,
My lord,
that my guide is sitting.
My lord.
So in that
Before that, it is
there are
not
two
possible to
aspects.
know, my lord.
Two aspects. One, if the supervisor is there there is no difficulty. Even in that case, when he participates. But when he recuses, What is the difficulty?
My lord, that is the point. Replacement.
That is out.
Replacement.
And we are not made parties also. Honorable single judge, we are not made parties. That is our.
If he recuses, then there should not be any difficulty.
Selected candidates, not party.
And you are saying because they were sitting in the room, therefore they might have influenced. Where is the question of they can influence them in the drawing room?
Correct.
My lord.
That is absolutely correct, my lord.
That is
Absolutely correct.
This is the only point.
That is the only point. On that.
So who are the others who appear? Who is not there?
Mr. Rath is there.
I am from the.
I am from the appellant in page number 1090 of 2019.
Who are the other side?
Other side, my London senior friend, probably. Mr. Rath is there for. Yes, for the.
We have made out of 9 candidates, we have made 4 selected candidates as parties. In terms of the Honorable Apex Court judgment, in the representative capacity, if some of the selected candidates are made parties, that will suffice the joinder of parties, my lord. Secondly, my lord, in the appointment order, it was clearly mentioned in the appointment order of the selectees that their appointment is subject to condition, outcome of the result of the writ petition.
All right.
Result of the writ petition was published in 11/7/22. After 1 year, they did not approach this honorable court, when knowing that their appointment, their selection was quashed by the honorable single judge. After 1 year, they approached this honorable court, and in similar cases, this honorable court has decided the ratio delay and lapses of 365 days is not condonable.
No, this is writ appeal.
Yes, madam.
We will see whether the limitation has been condoned in this case.
Not condoned.
No, all appeals are not filed within the, all appeals are, most of the appeals are filed within the period of limitation.
My lord.
1 or 2 is that.
First item that my lord.
All right, let us understand first. Who are the respondents? The contesting respondents.
My lord, in first item.
Contesting means the private respondent. Whether all of them are appearing or not.
Not yet.
My lord, they have not appeared. 2, 3, respondent 2, 3 and 4, they are not appearing. They have not appeared.
The university.
No,
And you are
the
working?
private candidates. The private.
Presently you are working.
Yes, I am.
My lord, I am for the writ appellant, selected candidate.
Yes, so you must be working as on it.
Yes, no, my lord. Item 2, I am the selective, but before joining in the post, in the place, this single judge passed the interim order so that I could not join.
Lordship, I am working as the professor in Ravenshaw University, and this honorable court granted status quo order with regard to my continuance.
We are continuing.
But I have not been.
No, I am not continuing.
Till yet, side most of that I am
But how to ensure their presence?
My lord, what it appears, whatever the address they are given in the writ petition, that address, in that address, perhaps they have sent the notice.
Yes.
And they have been made parties in that address. But if they are not receiving that one, deliberately they are not.
They are not
to delay the process.
In my case, your lordship, my London senior friend appearing for the petitioner that opposite party number 12, 14.
And lead petitioner has appeared. Lead petitioner has
appeared and filed their objection to my case also.
Go for paper publication.
That should be done by them. Because, my lord, the study is suffering in the affected in the universities.
All right.
And we have recommended everybody, and they are made parties, opposite parties. And we support the appellants only.
We understand.
Yes.
So notices are issued in all the cases.
Yes.
Let us make one more attempt.
Yes, that will take notice afresh.
And then
Against the person against whom the notice has not been served.
Better is paper publication.
No,
best.
let us make an attempt.
Yes. In all cases, it will be costlier for us. Okay. We'll take notice, my lord. 1 second, my lord, will give an opportunity.
Let first steps be taken for service of notice upon the non-appearing private respondents who registered as well as speed post. Requisites 1 week. Rule returnable 4 weeks. Stop. Let's just these appeals on 4 weeks.
10, 11 may be deleted. Because exports why should be made party.
Pro forma, they are pro forma.
Well, if this goes on, then we cannot get any exports.
No, they will be. they
Your
may
Lordship
be-
knows the Supreme Court judgment is there that these exports, all the interview board members, they should not be made party. They should not be even disclosed. Their identity should not be disclosed.
So they were party in the writ petition. They were party in the writ petition for which you have
Because
implemented.
they are alleging
But that did not appear, na?
Mr. They are alleging malafide.
Yes.
Therefore,
In that case,
they may choose to appear, may not choose to appear. That's a different matter.
they will never appear. They did not appear in the writ petition only.
Therefore, since they are alleging malafide, there is nothing wrong in including them also. All right.
Full text.
All right.
Lord, interim order not continue. All these things.
number
That is public.
Interim order is there.
Interim orders I'll continue with them.
Lordship have fixed a date so that
4 weeks. Date fixed.
Item number 26.
It's here in this case, Millets. I am for the respondent Millets. On the last occasion, Millets, the read applicant have filed an application for condonation of delay Millets. There is a 190 days delay in filing this read appeal Millets. And in that application Millets, nothing has been mentioned as to what is the cause of filing delay Millets. Only on the administrative ground Millets. I have filed an objection. Your Lordship may kindly turn to Your Lordship. I'll just pray your Lordships to kindly turn to page number 6, my Lordship. It's an order of Honorable Supreme Court, my Lords, wherein the Honorable Supreme Court had dismissed the SLP when in 180 when there is a delay of 182 days, my Lord, the petition was dismissed, my Lords. Lordship may kindly turn to page number 6.
Objection, have you handed over a copy?
Yes, my Lords.
So have you filed it online?
Online. I am filing in the court.
Online you have not filed, you are filing here. File it whenever you want. Place this matter on 1 week so as to enable learned counsel for the respondent to file objection to delimitation petition. What is the matter about?
Well, it's honorable single judge. Well, it's the REIT applicants is challenging the order at page number 16. The order of honorable single judge, my lords, wherein the honorable single judge has quashed the order of has quashed the order of applicants, my lords, and further directed the benefit wherein the prayer of the petitioner for the period of 18 months was rejected on the ground of no work, no pay. Honorable single judge has quashed that and directed the benefit of that 18 months. Your lordship may kindly turn to page number 19, my lords. Read application, page number 19. The second line, my lords. This is an observation, my lords. Page number 19, second line. Lordship, permit me, I'll just read.
So why did he not discharge his duty? Yes.
Yes. My lord, that is the only ground, my lord.
Then
The only ground, no work, no pay, because, yes, my lord, I cannot escape from the finding of the
Then-
honorable court that he submitted a joining report.
Yes.
And because of we wanted clarification from the director, he was not allowed.
All right. Then why should we
Madam.
delay condone? So stop. The state of Odisha has preferred this intra-court appeal, assailing an order dated 9/12/2022.
1912, 1912.
19/12/2022,
Madam.
passed by a learned single judge of this court, whereby the order dated 21/6/2017, passed by the Director Secondary Education Odisha, has been set aside, taking into account the ratio decided by the Supreme Court in case of Srimati Vishnu Priya Devi versus State of Odisha, reported in 2000. He relied on this.
Yes, yes, madam.
Relied on. Was reported in. What is that report? Odisha.
No, this is this court's order. Vishnu Priya Devi, this is of this court,
Not Supreme Court.
Not
WPC OAC. It is
Hang on.
transferred from.
yes, yes, madam.
Relying on a decision rendered by this court in case of Vishnu Priya Devi versus State of Odisha dated 13/9/2022, rendered in WPC bracketed OAC number 1095 of 2011. So stop. It is from the materials on record, it appears that the petitioner's representation to allow him salary for the period he was not allowed to discharge his or her
His
duties was rejected by the said representation dated 7/6/2013.
21/6/2017, my lords.
21/6/2017. Oh, stop. Next. Learned AGA representing the state of Odisha has not been able to point out any latches on the part of the respondent for his failure to discharge his duties. Oh, stop. It was because of the
Internal communication and clarification sought from the director.
it was because the matter got delayed.
Page number
So it was mainly because the matter as regards the joining of the respondent to the post of
driver
Against the post of junior clerk, adjusted against the post of junior clerk.
against the post of junior clerk remained stuck up for administrative reasons, comma, he could not discharge his duties. Full stop. The learned single judge, comma, in that background has rightly held that there being no fault on the part of the writ petitioner stroke the respondent, comma, he could not be deprived of his salary. So stop. In such view of the matter, this appeal is dismissed. The opposite parties are directed to comply with this court's order dated 19/12/2022 without any further delay.
grateful match. The pensionary benefit, the petitioner has been retired since 31/6/2022, my lord. The pensionary benefits. Grateful.
Item 27.
Item 27, this is covered by my lord's order.
Your lordship's order, I am for the response.
That GG, which order?
That
Rehabilitation national scheme. This covered by Malananda City as well as Bindusagar Samantra. Your lordship's order.
Terms of this.
Yes.
Item 28.
My lord, may I pray your lordship call this matter next week, because here I was directed to file an affidavit in the prescribed High Court rules. I could not file it today.
So should we take up the matter after completing 100 years of independence?
2004 matter, yes. That was dismissed for default and restored in 2023.
So if we wait for 23 years more, then we can reach that stage.
Last occasion, the lordships heard this matter, and in fact, the facts of the case is that here the petitioner, the opposite party, who was the petitioner before the Learned Central Tribunal, he joined the service in 1971 and he resigned in 1981. Thereafter, after the lapse of 18 years, he filed an application to the case before the Honorable Learned Tribunal, saying that I should, by the time I resigned, I had completed 10 years of service, so I should be paid pension. And the Learned Tribunal has allowed it, saying that the resignation amounts to retirement. Our specific objection was that Rule 26, one of the CCS Pension Law 1972 is a bar, because here the he has not withdrawn it with the permission. When the resignation has been accepted and he has been relieved, that means the past service is forfeited. On that ground, but the Learned Tribunal has not dealt with it. And
but why are you seeking adjournment?
By filing the affidavit, your lordship asked me in last occasion to file.
So why didn't you do the
form, the prescribed form, as per the High Court rule? Because the officers who had shown the affidavit, they had retired long since. So I have instructed the officer to come, but he could not come today.
So, but what do you say about the merits? Is there any illegality in the order?
Yes, my lord.
Who are you for?
I'm for the opposite party, number one.
How do you justify it?
Lordship, my resignation was a technical resignation. On the last date, your lordships have put me a question on limitation, because I had already I had filed the OA in tribunal after 18 years of delay. The Lordship, pension is a continuing wrong and the cause of action accrues each and every month. As
Very difficult to accept that contention, Mr. Counsel.
Lordship in Tarsem Singh versus Union of India.
Yes, in appropriate cases, yes, but not in all the cases.
Lordship, I can explain.
Huh?
I can explain.
Explain. All right, we are ready to see Tarsem Singh. Show us. That will not apply in your case because you had resigned.
In that case, he resigned and joined in the same department in another post. The case which was resigned by learned friend, in that case, he resigned and again joined in the very same department. But while calculating the pension, that period he served in the earlier department was not taken into consideration. In that case, and he came 6 years late.
Then he has a case.
It is not the case here.
If he resigned only for the purpose of joining another post in the same department.
No, he has not joined. He has not joined.
He has not joined.
No.
Lordship, I've joined state government services. I've resigned.
State government is different.
Lordship, there was a memorandum by. Lordship.
Yes, we are ready to hear you.
Pension, CCS pension.
Did you retire from the post which you held in the state government?
Yes, your Lordship.
So you must be getting full pension from the state government?
I'm getting pension since 2004. I had served there for 23 years only. Actually.
So pension from the state government and pension from the central government. This is what you want.
Lordship. I want my service. My service will not be forfeited because I had joined the state government after the proper permission, and this is a technical resignation. You know.
All right, we will see. Show us.
Your Lordship, I have another book.
You are relying on rule?
Mention 26
Lordship,
one.
office memorandum issued by.
Just a minute. Union of India is relying on?
26-1, my lord. Of the CCS, 26-1 of the CCS pension rule, my lord.
And you?
My friend is relying on some
memorandums
circulars.
issued by Government of India from time.
Page?
Appendix 7 of the.
Appendix 7.
Lordship. Order 6, 7, and 3.
Yes. Appendix 7 where?
Lordship, Order 6, sub order 3, page number 409.
Appendix 7.
Appendix 6. Top.
Appendix.
Appendix 7. Sorry, Your Lordship. Appendix 7, Order 6, sub order 3. It's office memorandum issued by Department of Pension and Pensioner Welfare.
Just a minute. You are relying on Appendix 7.
Order 6.
What is the page number?
401.
401. Appendix 7.
Lordship, mine may be a different edition. Mine is 13th edition.
What does it take 6 seconds to translate?
7, 6.
Order 6.
Yes.
Yes.
Lordship, sub-order 3, memorandum of 19th April 1999. It starts with counting of past services on mobility of employees from central or state government department to central or state autonomous bodies accepted of related options for counting of past services.
No, where are reading? Yes, 409.
409.
Yes. Yes, please.
May I read your Lordship?
Yes, so what does it say?
Lordship, this is the background fact of my case. In 1999 only, I came to know about the 84 memorandum and the 86 memorandum, which says the employees who were resigned from the government services of the government of India to join the services of the state
Where
government.
is that expression used, resignation? Where is that resignation used in this order 3, sub-order 3?
Lordship, that is in 84 memorandum, which this order is referring. That is order 6, page number 405, paragraph 6.
What for? What is that, paragraph 6?
These orders will be applicable only where the transfer of the employees from one organization to another was or is with the consent of the organization under which he was serving earlier, including the cases where the individual had secured employment directly on his own volition, provided he had applied through proper channel with proper permission of the administrative authority concerned. Lordship, I was not observed. I applied through proper channel and I got relieved. Then I joined the state services. And this 84 memorandum, this is 1984 memorandum, Your Lordship, and that was extended to the state government employees in the order of 7th February 1986 memorandum. That is in order 7 of appendix 7.
What is there?
Your Lordship, in 84 memorandum, the employees of the central government who were observed in the central...
Mr. Counsel, simple question is that if an employee of the central government resigns with a permission to join a post in the state government, you are entitled for pension from the central government. This is your case? So on what basis you are saying this?
Your Lordship, under Rule 20...
First of all, you will have to demonstrate that you had resigned with an intimation to your employer that you were going to join a post in the state government. All right. So there are two things. One, intimation, and two, your joining in fact. So these two things are admitted.
This is not disputed in the...
Please, if you could have said yes or no.
Yes, sir.
So this is admitted that you, while putting your papers, you had mentioned that you are going to join somewhere in the state government, and therefore you are resigning.
Lordship.
Where is that?
Lordship, while I was resigning in 81, there was a bifurcation of department. In my original application in the tribunal, I had only annexed the appointment letter and the relieving order. And the other orders, my permission letter and my resignation letter that was with the department. I have asked the department, but they didn't provide it. So I have not annexed it.
It is your document. Resignation is your document.
Lordship.
Your document, why should?
Lordship, in state of Rajasthan versus O.P. Gupta, the Honorable Supreme Court held that after a long period of delay, if there is no proper proof, then the proper permission will be presumed.
Mr. Counsel, the problem is that you are stating so many principles of law, but you are not applying those principles to your facts. In this judgment, the Supreme Court said that, Tarsem Singh said this, the Supreme Court said this, and then this rule says that, and then the order said this. But you are not saying that your resignation was your decision to live. And therefore, why section 26, one shall have no rules, 26, one shall have no application. Why rule 26, one shall have no application? Let us understand. Otherwise, that provision is redundant.
Lordship, in 1984 only, the government brought up with the pro rata pension provisions, because after that only.
When did you resign?
In 1981. Lordship, I was in service from 1971 to 81.
So how 84 will apply in your case?
That was applied retrospectively in 1988.
88 is retrospective.
In 1988, the 84 memorandum was made retrospective to the persons who were Lordship, I have in 26(1) it will be forfeiture if I had only resigned for. In my case, it was a technical resignation to join other services, another state government services. I resigned. In that case, 26(2) will apply.
So therefore, we wanted to see the resignation letter. You don't have that.
I don't have that.
Then.
Because in 81 I resigned, and in 1999 I filed the OA in the tribunal. And in the meantime, in the meantime, documents were misplaced.
In the sorry.
And how do we read the state government here? Under the government?
Lordship, that is clarified by the by issuing various memorandum from time to time. The Government of India decisions.
Where are they?
And these are the decision: 84 office memorandum and 86 memorandum. 84 memorandum says, that is Appendix 7. Lordship may refer page number 413. Paragraph 3.
So these aspects were considered by the tribunal.
The tribunal had only one issue in paragraph 3 of the order of the tribunal. The tribunal had only one issue to be adjudicated, that my service, whether it will qualify for pension or it will be forfeited. and the tribunal ruled in my favor that my services.
On what basis?
That time, the tribunal relied upon a judgment of the Supreme Court. That is, the resignation amounts to retirement in J.K. Cotton judgment.
My God.
Without citing any of the judgments,
So you are relying on this Roman 3
Your Lordship.
and you are relying on what?
Appendix 7, Order 6, Order 7, and Order 4.
Order?
6, Order 7, and Order 4.
Order 6, Order 7 and Order 4.
Your Lordship.
Nothing more than that?
And the 1965 office memorandum. That is the technical resignation.
Where is that?
That is at page number 57.
Just consolidated guidelines.
Consolidated guidelines. Page 57 and 60.
Roman 3 is not. So how do you rely on this? In the same or some other department? So this department is not of the state government, it is of the central government.
Lordship. That is again clarified in 1986 memorandum. Your Lordship may kindly refer, see 1986 memorandum at page 413, paragraph 3. May I read you?
So your submission is that your resignation was not a resignation for applying Rule 26(1), rather it was a technical resignation, 1. And 2, because you moved to the state government from the central government, therefore you are entitled for pension for that period. 3, that you are relying on Supreme Court's decision also. Which decision?
State of Rajasthan versus OP Gupta.
State of
That is annexer FY1.
Yes, Your Lordship. I have annexed that.
Rajasthan versus
State of Rajasthan versus OP Gupta.
There is a question of delay.
And another judgment I have of the Honorable Delhi High Court.
yes.
I have the judgment. North Delhi Municipal Corporation versus Dr. Nazim Ilahi.
North Delhi
Municipal Corporation versus Dr. Nizam Ilahi.
Doctor
Doctor
Nizam
Nizam Ilahi.
All right.
Lord, may I say a word in reply? May I place a word in reply, my lord? Here the applicant's case before the London Tribunal, the application I have annexed. That is annexer 1 series, my lord. There he has said that I joined in 6/6/1971. Then in paragraph 3 he stated that it is humbly submitted that in order to be appointed elsewhere in better post, stroke job, the petitioner submitted his resignation, and pursuant to his resignation letter, the petitioner was relieved on 6/12/1981 by letter number such and such. A copy of the such is annexed. This is the only document he has submitted along with the petition. It was never stated that I sought permission to be joined elsewhere or that I joined subsequently in the government and I retired. That nothing has been stated. And the circular my friend is relied on, that is also very clear. In page 25 of the counter affidavit filed by my friend, that is office memorandum dated 22nd January 1993. Page 25 of that. There also it is stated the government servant at the time of joining should intimate the details, and the government servant in the time of resignation should specifically make a request indicating the dates that he is resigning to take up another appointment under the government or government organization, that under the central government. He has not. And another also circular.
When did you join in central state government?
Lordship, in 1971.
State government.
State government.
2000.
That is not there in the original application.
When did you?
1981.
Nothing.
Where have you stated?
Nothing has been stated.
On what basis you are making this statement?
Lordship, that time I had only stated that to be appointed elsewhere. I had given.
We have put a question, Mr. Counsel, that after resigning, when did you join the state government?
Lordship, I have annexed the pension payment order of my.
Do you have any answer to the query? When did you join?
In 1981, I do not remember.
On what basis you are making this statement?
Lordship, I was relieved to be joined only in the state government. I was thoroughly relieved to join the state government services immediately after my joining.
Where is that?
I had only annexed the resignation, the relieving order.
So is it mentioned in the relieving order that you are going to join a post?
No, Your Lordship.
Then on what basis you are saying that you had joined?
In my original application, only I had mentioned that. Your Lordship, that time the office memorandums were using the term appointment elsewhere. So I only used that term to be appointed elsewhere. And my resignation.
Mr. Counsel, this is the 5th time we are putting this question. When did you join after being relieved?
I'll take the instruction.
Where is the question of taking instruction after 30 years? File your affidavit.
My lord.
And counsel for the petitioner is permitted to file an additional affidavit supporting the averments made in the writ petition. First off, the points raised in the present writ petition, legal issues involved in the present writ application have been addressed at length by the parties. First off, the court will consider disposing of this writ petition on the next date.
Item 29.
In behalf of the petitioner in this matter, my lords. My lords, we need further instruction as to whether the petitioner is going to pursue the matter or not. My lords, may I kindly grant 1 week time.
How much?
My lords, 1 week time.
As requested on behalf of the petitioner to seek instructions as to whether the cause of action survives or not. Omar lists this matter on 1 week.
My lord, evening otherwise, my lord, the appeal is pending before the appropriate authorities, my lord. So we appeal. They are also participating, my lords. That is also we have annexed in the counter. Appeal is still pending, my lords, and they are participating. As per their, they have also admitted. So appeal may be pursued, my lord. They are participating in the appeal. The title will be decided by the appellate authority, my lords. Here they have challenged to an eviction order by the Endowment Commissioner, my lords. Main title proceeding is pending.
Yes. What do you suggest? All right, 1 week.
Within a week, my lord?
Yes, 1 week.
Item 30.
May please.
Yes.
Here the petition has filed this litigation for a direction to the opposite parties to allot a land under the slum dweller rehabilitation scheme, my lord. But the petitioner father was staying for last 30 years. And thereafter the present petitioner is staying. The similar situated person, those who have residing in the slum area, they have been allotted the land and they have constructed their house. Since the case of the petitioner has not considered, he has approached this honorable court. But the lordship has directed the issue notice to the opposite parties to file their counter. In the meantime, I have filed miscase at that time, my lord, for addition of the state officer to as the parties, my lord. Noting is that recusa is not filed due to non-filing of the recusates, my lord.
Filing of?
Filing of recusates, my lord. So,
filing of what? Filing of what?
Non-filing of the postal recusates. For issuance of notice to the opposite party. Number 3, newly added opposite party. Number 3, my lord. State officer is the necessary party member where notice has been issued. So I may be permitted to serve an extra copy to that government council so that it will be.
Where is that scheme?
Slum dwellers rehabilitation scheme, my.
But this matter is pending for last 13 years.
13 years, my.
Now the plot may not be available.
During pendency of this writ application, another notice was issued by the housing board, where the petitioner has approved this honorable board, where direction has been issued to the housing board to consider the case of the petitioner, and he will file the petition. That is also, he has filed the petition that is pending, my lord. Only this case is different because we were paying for the land in question under the scheme,
So they will consider
my lord.
15 feet into 23 feet. And how can we decide?
Plot may not be also available. Now scheme may not be there. And plot also will not be there.
That scheme is.
Under
I think
annexure
there is
three.
no more.
Under annexure 3 that has
Your old.
similarly situated person has been allotted by phase 2 and 5.
If now plots are not
Yeah, he
available.
is staying. Agent
It is in
petition is
the-
residing on that space.
Heart of the.
For last 40 years, he is residing.
It is situated in the heart of the Bhubaneswar town, Satyanagar. So whether that scheme is still in operation.
Under
or
annexure
whether
3
he's-
is
Your
similar
lordship may
importance
direct
of
that if he is eligible to get any, then the authority may consider and pass appropriate order.
Writ application under Article 226 of the Constitution of India was filed nearly 13 years ago in 2011, seeking a direction to the opposite parties number 1 and 2 to allot the petitioner a land under the slum dweller rehabilitation scheme at the slum dwellers council colony at Satyanagar, Bhubaneswar. Stop. On the date of filing of the writ petition, the petitioner was aged 44 years. Stop. He has asserted in the writ petition that he had been living in the said slum with his family members for last 30 years. So you were 14 years.
Now 40 years. Father was staying, thereafter son is staying.
All right. With a hope that land in question will be allotted in his favor under the slum dweller rehabilitation scheme. When was it framed? When was the scheme framed?
Framed in lordship that is 2008, my lord.
Annexure 3.
3, my lord.
Framed in
That is provisional allotment.
Allotment, my lord. In favor of some other similar
2008. Stop. It is also the petitioner's case that he had made an application under the same said scheme for allotment of land
To the Orissa State Housing Board.
to the Odisha State Housing Board.
Opposite
Stop.
part number 2.
Considering the, have you filed any affidavit after?
Government council.
No,
there is no pleading other than the pleadings in the writ petition on record to give any hint about development subsequent to filing of the writ petition. Stop. Next. In such view of the matter, comma, without expressing any opinion on the merits of the case, we dispose of the presented application with a liberty to the petitioner to approach
Opposite part number 2, Orissa State Housing Board.
the opposite party number 2 under the said scheme, comma, if the scheme still survives and the land in question is available, comma, for provisional allotment of land. Also, of this application stands disposed of accordingly.
Interim order was there, ma'am.
No interim order.
Status quo maybe.
Item 31.
I am continuing that plot my land for last 40 years. Ma'am. Between petitioner is continuing with that plot for last 40 years. Ma'am. So
we have not said anything.
31 not pressed, madam. Not pressed.
Not pressed.
Item 32.
32 will not pressed.
Not pressed. This is also a very good way of disposing of cases. Keep the matters pending for
On the last
decades.
on the last date, your lordship directed both the parties to come up with the up-to-date case laws. He has filed a case law. I have also filed a court-based decision.
All right, forget.
Item 33.
Mr. in item number 33, Lordship, sir, please to grant me time last occasion to file an affidavit by the Tahsildar. But sir, I need some more time. Lordship may grant me 2 weeks time to file the affidavit by the Tahsildar. Lordship.
Take only a short date may be given, my lord. That's my only prayer, my lord.
2 weeks as
Yes.
requested on behalf of the estate. 2 weeks further time is allowed as requested on behalf of the estate to file counter affidavit.
Counter has been filed. This affidavit specifically directed by Lordship to be filed by the Tahsildar.
To file affidavit, what? Where is the order?
Yes, order dated in compliance of order dated 30th of January 2024.
Order number 25, lordship may kindly see.
Order number 25.
25, my lord.
What is it? WPC 649. Huh?
Item 33.
No, yes, it's WPC 22841 over 2012.
33.
Order number?
25, my lord. Dated 31/24.
Telga, 2 weeks further time is allowed for the, no, 26.
There the petitioners have already complied that order, my lord. Filing of, my lord, supplementary affidavit. That I have already filed.
No, there was again a direction 26, order number 26. 1 week further time is allowed to state opposite
No.
parties to file affidavit in compliance of this court's order. So,
30th January, Lordship passed the order. Thereafter, 30th of February,
13th of February.
February, you also granted me time. I told your Lordship, Lordship, were pleased to grant me time earlier also, my Lordship.
Why?
No, because the Tahsildar who has to file that affidavit, Milords, he was on election Milords meeting, that today he could not file. So that's a 1 week time also I can file it, Milords.
क्या लिखा? So 1 week further time is allowed to comply with this court's order dated 31/2024 and 13/2024. So stop. The court takes serious view of non-compliance of the aforesaid two orders. So if on the next date no affidavit is filed by the Tahsildar, which place?
Dharamgarh, Milords.
Dharamgarh.
Milords.
The court. क्या लिखा? The Tahsildar shall be required to be personally present in court when this court will consider initiating contempt proceeding against him.
Item 34.
Here for opposite party.
She is for OP number 10.
So the petitioner is not appearing.
Not
on the last occasion also.
Yes.
Last occasion also he.
Council is there since long. Bahal is normal.
Bahal.
Rajashri Bahal.
Yes.
She used to come from Bhubaneswar. She is no more.
She is
Since
no
long.
more.
Since long she is not.
Yes.
Oh, Rajashri. Yes, yes.
But petitioner is also not taking any interest.
Petitioner is also not interested in these things.
This matter is pending before this court since 2013. Stop. There is no representation on his behalf. Stop. It appears that the petitioner has lost interest in this matter, which stands dismissed for default.
Item 35.
No one appears on behalf of the petitioner. This application, petitioners, this application is accordingly dismissed for non-prosecution.
Item number 36.
But here, Lordships, last occasion was so wide order dated.
Yes.
13-2 were pleased to grant time not to the state to file a counter affidavit. Because even though it's a old matter and the virus of the amendment to the OGLS rules is under challenge. So I discussed, I had drafted the counter affidavit. 1 week time may be granted to filing the same.
No, but is counter affidavit required, Mr.?
Factual aspects are there, therefore you must look to that order dated 22/1/2020.
Factual aspect in
Right, the virus matters. Virus may not be necessary, but it requires also a little bit.
virus may
Yes,
not be.
may not be.
File your affidavit
Later, I pray about 2 weeks.
by way of last and 2 weeks. Further time is allowed for the state to file counter affidavit.
But interim order is there. There are two matters, my lord. I am in the second matter. The interim order is there.
Shall continue in the meeting.
Great.
Item 37.
May I please, Your Lordship? First, I want to draw Your Lordship's attention, IA number 1745. It is the Order 1, Rule 10 petitions. As because I have filed these petitions for impleading the Sarpanch of Chandipur as opposite party number 6 instead of Sarpanch of Sarikana Muja. As because during the pendency of these writ petitions, the village came into the Chandipur GP instead of Srikana GP. So Srikana Chandipur Gram Panchayat is the Sarpanch of the Chandipur Gram Panchayat is the necessary party. Without impleading him, a particular order cannot be. And this order.
But without impleading him, if there is no merit in your case, then it can be dismissed.
No, this.
Even for dismissal, impleadment is required.
And because that compliance, Chandipur Sarpanch is the party to comply the order of this Honorable Court. It is covered matter. It has been already decided by this Honorable Court. In the main case is 2005 to 4/6 of 2014. The order which has been annexed in this petition. Annexed. It has been already in the file. I will tell. It has been decided by this Honorable Court on August 2023.
Where is this order?
Order
dated 18/8/2023.
Yes, it is already. Your Lordship called the order, then it is already in the file.
It is in the file.
Yes.
9/8/2023.
No.
Similar.
In the file is the 20,596 of 14. It has been already in the order. That decided it is already decided by this Honorable Court for payment of the minimum wages to the employee.
That is what I am saying. You have enclosed. Like 9/8/2023 order.
Yes, my lord.
That is what I am asking.
On the basis of that order, my petition be disposed of, impleading the Sarpanch of the Chandipur Gram Panchayat. As because within this pendants of the writ petitions, the Sarpanch has been changed. Same village, same block, same district, everything is Sarpanch is changed. The area of that village.
Just wait for the other side.
I am appearing for the copy of that order may be served on me, or I will
give him a copy of the order.
And also petition copy not served.
Yes,
IA and copy of the order.
I copy order. I will serve in the court.
Every time we are adjourning the matter. Tomorrow we will not adjourn. Please see the order. Why are you seeking copy of the order? That just see take the date of the disposal and.
Yes, I'll download it from.
Yes.
Well,
you may not. You see and
20,526 of 2014. Tikeman Sahu.
I'll verify.
Division bench decision.
I'll verify.
Is this matter tomorrow as requested on behalf of the estate?
And that decision also, their lordships have relied on another division bench decision of this court. 28/3/2023.
Item 38.
I have filed the cause title of this petition. Considered cause title I have already filed.
Your IA has
I-
not yet been. your
We'll
IA
see
has-
tomorrow.
Item 38.
Published.
Lord, in this case, pursuant to your lordship's order dated 6 January 2024, we have filed an affidavit on 24th January 2024. The hard copies are filed, but copy has not been served. But unfortunately, I am not getting the affidavit copy. May take only 1 day time. I'll take a copy and serve copy on my learned senior, and your lordship may take it up day after tomorrow.
So let him serve a copy. Let
I'll
come next
take-
week because I have to go through the affidavit and what they have filed.
I'll take.
As requested on behalf of the estate, let this matter on 1 week. 1 week?
Yes, 1 week.
1 week. Let a copy of the counter affidavit.
So,
Additional affidavit.
Counter has been filed.
Counter only an affidavit. Dated
Affidavit.
24th January 2020.
Let copy of the affidavit be served upon learned counsel for the petitioner
Yes.
by tomorrow.
Item 39.
39, my lord. I am for the petition, my lord. On 20th of this month, I received additional affidavit, my lord, regarding the publishment of result of which was in on of dated at the which are the selection regarding the selection which has been fixed to 25/7/2023. The additional affidavit are received on 20th. So, my lord, I need only 2 to 3 days to take instruction, my lord.
What is this matter about? Any
Matter
idea?
is about it is a nature of PI. The REIT is nature of PIL, my lord. That and the matter is about not extending the benefits of boxings to the aspect of boxing which has been provided where all the benefits are provided to all other sports events, but the same benefits are not provided to the boxing event. I'm a social activist, and it's the matter is all the counter received and additional affidavit also filed. Again, counter is and the last I have received the additional affidavit on 20th of this month. So I need for the 2 to 3 days time to take further instruction.
So which other sport is not being promoted in the estate?
Sorry, my
Which
lord.
other sports? Which is the other sports in the state of Odisha which is not being promoted? You are concerned with boxing.
Boxing.
The first question is why.
Yes.
The second question is why the state of Odisha should promote.
My lord, that is no such specific selection procedure was there that how the boxing the vacancy for boxing seats will be filled up.
Vacancy again is a different thing. Vacancy, when the moment you talk of vacancy, then the nature of the proceeding changes.
My lord, for a moment, if your lordship may go through the paragraph 5.5 of my writ petition, that is the main point of disagreement. That in this above notice, 16 seats, 8 boys and 8 girls are allotted for boxing discipline. Further to state that in every year, candidates selected in annual talent scouting have been admitted to the sports hostel. But as some promising sports and could not get chance to participate in talent scouting program by notification dated 26/11/2014, decision are taken by the government for lateral entry. This for all sports, but no so specific procedure is there how the seat of vacancy of boxing will be filled up, and other things are that no such.
Then it is no more a public interest litigation.
Yes, my lord.
Actually, my lord, it is not a public interest, but your lordship has directed the state to give affidavit as to whether any talent scouting program was conducted in respect of this particular sport. Actually, it is being conducted, and the last year result I have filed under affidavit, which my learned sister is trying to give a response to it. All the persons appeared are declared disqualified, all of them. So it's not a fact that we are not conducting that talent scouting program, but it is being conducted, but all of them are becomes disqualified. So the petitioner is interested for a particular admission in a sports hostel on the basis of this particular sports game as a sports game, but all of them are disqualified. This is the position. If she wants to give a response to this affidavit, I have no objection, because this is the fact which I have, the government notification, government result sheet I have annexed to my affidavit.
That I don't do. That is why I need.
So boxing does not figure in your scheme of sports.
Boxing figures in scheme of sports, and we used to conduct talent scouting program on each year. But so far as this year is concerned, nobody would be qualified.
This year means?
This is for 23-24.
My lord, if you lordship for a moment, kindly paragraph 5.8 of my writ petition. Should I read out, my lord?
Yes.
That in other state, the sports hostels are being managed by army, for which the interested candidates are getting proper training and facilities from the age of 12. But in Odisha, it is control and manage under the Sports and Youth Service Department, which is not taking appropriate step to provide such benefit facility to the boxer. That's why they are being, the talent are being diverted to other state, or they are moving other state to take boxing as their career. So
We can ask them to consider. We cannot issue any direction. We can dispose it off with an observation.
No, I just need a short adjournment.
All right, as requested on behalf of the.
So that I verify the whether.
Let us see. Let this matter on 1 week.
Item 40.
Oh, bless you.
40, my lords, this is at the instance of the state legal services authority regarding the issue of fake doctors, my lord. If my lord would see order number 10, dated
yes.
Order number 10 dated 22/6/2023. A specific set of directions were given by this court. In paragraph 5, the affidavit of the state was extracted. I hope my lord got it. Order number 10 dated 22/6/2023.
Yes.
And after extracting the government's affidavit, in paragraph 6, the court goes on to record that Mr. So-and-so amicus has urged this court to direct the state opposite parties to file an affidavit as regards the status of implementation of the steps assured to be taken by the state opposite parties. He also contended that the state opposite parties should also apprise this court that whether there is any surveillance mechanism to find out the fake doctors in the state. If there is no such mechanism, what steps the government is contemplating to take in order to curb the menace of fake doctors, and what further action the state opposite parties propose to take against the establishments either run by fake doctors or collaborated by them. Then in para 7, 2 specific queries were formulated. Para 1, whether the steps reproduced above have been implemented, information shall be filed in tabular form. Para 2, 7.2 would be very important. Whether any surveillance mechanism to identify the fake doctors is operating in the state of Orissa. If not, whether the state opposite parties are contemplating to introduce surveillance. Now, in view of this order, they have come up with an affidavit which is at flag F. Now, if my lord would see that affidavit dated 28/7/2023, this direction of the court regarding surveillance has not been at all addressed. Now, what they are basically saying in their affidavit, if my lord sees that, it would be that they are basically trying to check the existing doctors, the in-house doctors, their certificates have, some steps have been taken to check. Means doctors who are already in the establishment, existing set of allopathic doctors.
Establishment of the government or?
Of the government.
Otherwise also.
My lords.
of the government and outside also. But registered medical practitioners, their licenses have been checked. But what probably the court meant was Ayush doctors posing themselves to be MBBS doctors, or maybe outright quacks. This problem, my lord, is basically in the tribal belt. It's not in these prominent districts where people are much more aware. So, in fact, I have made a short note for the convenience of this court. In fact, if my lord would allow me, on 27/1/2023, the proceedings of the court were live streamed where the health secretary also appeared. There, the interaction between my lord Justice Aman was also a part of that bench, my lords. There, the court did say that in Delhi and Punjab and Haryana also, there is this problem of Ayush doctors posing themselves to be MBBS doctors. How to curb that? That was also a query posed by the court. They did say that we'll bring in with some policy to deal with this.
I think during COVID, we.
No, this was on 27/1/2023. So I think just we were out of COVID. COVID got over March, I think, just out of COVID. But I have just made a short convenience note. If my lord would just see, I'm tendering a hard copy of this.
Yes.
So the core issue is they are sidetracking that. The core issue is how do you catch hold of the ones who are outside your establishment, the quacks, that they are not answering. Then, my lords, there was a request made for an online database for doctors. That was recorded in that order also. Point number D of my note today. That they are not, because if there's an online database of all the medical practitioners, then the people would probably be able to cross-check that whether this person is genuine or fake. That proposal was mooted and they had accepted that, but I think no steps in that regard also have been taken. And their affidavit completely ignores this query of the court made on 22/6/2023 as to what they would do regarding surveillance. That they are not answering at all. So these are the broad points I've just listed out in my note. My lord may consider their affidavit which they have filed.
What do you suggest?
Now, this online database is something which I feel, it's of course my suggestion which was accepted by the court. That is something which in this age of digitization, it may help. And that won't be very expensive for the government. Having an online database of existing allopathic doctors would not be very expensive. And the data is there with them. They registered practitioners. Now they have conducted this exercise of checking the licenses of the existing doctors. So the data is very much available with them. So that is something which they could have done. Now almost 1 year is over. And regarding this surveillance, they have to come up, they probably have to...
But this online database,
my lord,
can be provided by the state medical council. State medical council is there?
No, sir. In fact, it can be also because they are registered, all the medical practitioners, they are also registered on the state. That can also be done, Lord. So I will take instruction that I can...
Can that be done?
Yes, my lord. In fact, in food security, I am also assisting the court. In that, they have taken some steps. If they have the inclination, they can easily come up with a database. It's a website which will have all the doctors enlisted. So suppose somebody wants to check or there's some doubt, that can be...
No, that is not the question. Question, Mr. Mishra, is that you can identify,
my lord,
as to who is a qualified doctor. But the tribals cannot.
My lord.
The persons who are illiterate, they may not have the access to whatever database you
my lord. I completely bow down to that. But
so therefore you will have to go into the root of the matter to ensure that these innocent people, illiterate people, they are not made to suffer because of these frauds. So the database, it is not a very difficult exercise. That can be done, of course, with the aid of the State Medical Council and some other agency, government also, if all of them combine and prepare their database, yes, that should be prepared, that can be done. But there should be some mechanism to locate them.
Manoj, I completely bow down. In fact, that online database is just a small solution. It can't be the entire problem can't be solved by the online data. That never, I never suggested that. That's something.
Then we should accept the ground reality that you call them quirks or whatever, they have support at that level. They are identified, they have more recognition than a qualified doctor.
Right.
More acceptability. Then another question arises, they need to be informed, those persons.
All those complex issues are there. This surveillance
and I'm very happy about this thing that the Orissa Legal Service Authority has taken up the cause.
Yes.
It's a good public cause. We are impleading State Medical Council.
I think they are
Someone is there.
State Medical Council is there. I am for National Medical Council, my friend.
Yes.
State Medical Council is there.
There are
We got the registration for the doctors.
Which is that act which governs medical profession? Medical Council Act.
Medical Commission now.
Now the new act has come, the National Medical Commission Act 2019.
Yes.
And State Medical Council is OP number 3 in this writ petition.
That is only registration.
That is for registration.
Medical council
They
for
get the registration for the state medical officers, medical doctors. And after that, we get them registered in the National Medical Commission, Medical Council.
And the health secretary is there as OP number 1.
Health secretary
is there as OP number 1.
You can do one thing. It's just a suggestion, subject to what all of you say. That as on date, when we accept Ayurveda, homeopath, and other indigenous system of medicines, then everyone may have some kind of sign of identity. That he is an MBBS doctor or allopathic doctor, someone is Ayurvedic doctor. So everyone, if someone is found practicing as a practicing medicine, either of these three or four, then they must have something to say that yes, I am allopathic doctor, I am this, I am this, I am this. So this system you may consider introducing.
Right, but
This can be one thing.
Number of persons, those who are practicing in homeopathy and Ayurveda, they are do it by way of lineage. They don't have any qualification or any degree.
They cannot.
That's why, but in the rural areas, they are more popular than
maybe more popular, but the people will have to be told that if you say tantric methods are still popular, but it does not mean that we should support or we should not discourage them, and we should not make the people aware about that. So, who is for the State Medical Council?
No, I can appear, because it's functionary of state, I can also appear, because I am appearing for OP number 1. I can also appear for OP number 3, who is the State Medical Council.
State Medical Council, you should not appear.
There is one panel of advocates.
Not only that, since you are representing the estate, you should not appear because there may be clash of interests between you and the State Medical Council. We don't know at what stage that clash may arise.
In that case, my notice may be issued to them
No, someone is appearing, you say that.
I will get the information to you. Let me inquire. Mr. Bose was appearing in some of the cases 2-3 years back, but let me confirm today and I will inform my lord.
Considering the significance of the issue which the present proceeding in the nature of public interest litigation involves relating to the doctors practicing on fake / forced / without degrees, comma, we consider it proper in the interest of justice to request the chairman, State Medical Council.
Yes, State Medical Council.
State is chairman, Odisha Medical Council. Is it correct?
No,
The name of the body?
State Medical Council.
Odisha Council for Medical Registration.
Odisha Council for
Medical Registration, OP number 3, no, it's here.
Medical Registration, OP number 3, to be present in the court on the next date when that is 1 week when we shall take up the matter again. Stop. We are making this request in the present order for personal appearance of the chairman of so and so for eliciting opinion from him to effectively deal with the menace which the society is facing. Stop. Next, we do appreciate the endeavor made by Mr. Mishra and amicus curiae while making certain valuable suggestions to the court in this regard. Stop. One of the suggestion which he has made is that there is a need of having a comprehensive online database of all the medical practitioners in the state of Odisha accessible to the general public to cross-check the genuineness of all medical practitioners. Stop. A preparation of such database may provide necessary checks and balances from fake doctors administering allopathic medicines, comma, he has suggested. Stop. He has also drawn our attention to non-compliance by the respondents of the orders of this court dated 22/6/2023, bracketed paragraph 7(1), 7 bracketed Roman 1 and 7(2), as also the order dated 27/1/2023, bracketed paragraph 5. So stop. On the next date, we shall take up the issue of non-compliance of previous orders passed by this court in the present proceeding. Full stop. Next. There cannot be gainsaying that conduct of persons acting as doctors without any valid degree/certificate constitute criminal offenses. First off, we do not have any clue as to whether criminal cases have been registered in this regard or not. First off, we shall address this aspect also on the next date. First off, list this matter on 1 week. Yes.
Yeah.
Find out. And who will inform? Please inform.
One more thing for NMC.
Learned counsel for the
National Medical Commission.
National Medical Commission undertakes that he shall be informing the chairman so and so of the about the today's order.
Lordship said directed that chairman, Lordship say it's president, because it has been addressed.
President.
Instead of the chairman, it would be
President. Chairman is our president. You just tell him that it is not that we have directed for his personal appearance. We also, this is a public interest litigation. Everyone, he is also a stakeholder, important stakeholder.
Should help the honorable court for.
Yes.
May I just suggest, my lord, since my lord is directing him to appear, a time may be fixed so that it may be.
Yes, at 2.
2 o'clock.
Yes, 2 I can. Yes, 2. 2 we can fix.
That may be reflected in the order.
2 at 2 p.m. To be taken up at 2 p.m.
We are all grateful.
Item number 41.
The matter is related for the opposite parties. Let me for each time to file my objection to the condemnation of delay.
How much delay?
For 1 year.
1 year.
And that is during COVID period, Malad. I have attached the
COVID period.
Yes, system generated copy I have also attached during filing, and they are to obtain the certified copy from the registry and file before the Honorable Court.
Why?
File has been misplaced. That is
Misplaced that. Please, we can adjourn your case on that ground.
otherwise, you would have filed an objection. Milord, I will file also objection. In the meanwhile, the Lordship may consider it.
As requested on behalf of the respondent, list this matter on 2 weeks.
Item 42.
Item 52, with your lordship kind permission, state is the appellant. If your lordship will turn to, we have some similar appeals have been already dismissed. I'm showing your lordship at page 130, 144, at page 146. Lordship, kindly come to page 146. That is the internal page 15 of the impugned judgment.
Similar orders.
Yes, similar view has already been taken by this court in Niharanjan Sarangi case. That Niharanjan Sarangi case, let's look to that judgment. This Niharanjan Sarangi
I
case.
may place my
Just 1 minute.
No, please let him say it. Sir, when a senior counsel is on
Sorry, Mal. Because I am submitting because I am the appellant.
No, that is exactly what I'm raising the question of.
Yes.
This Niharanjan Sarangi case was challenged in writ appeal number 1028 of 2022. The writ appeal has been dismissed. That is writ appeal number 1028 of 2022, dismissed on 17/11/2023. Paragraph 6 of that judgment of Niharanjan case, where the very issue which was involved in that case, that was decided in that Niharanjan case by a coordinate bench. And that Niharanjan case was relied upon in the interim judgment to decide the matter on merit. So far as this writ appeal was listed along with those writ appeals, including the case of Niharanjan Sarangi, and those writ appeals were listed on that list also I have brought. But because that all those cases were disposed of by a coordinate bench, but a division bench consisting of Justice Sarangi and the Honorable Justice Justice Raman, in fact, dismissed those appeals.
Ground of delay. On ground of
delay, yes. Because the judgment has now been upheld. So far, the judgment now been upheld in all the cases, except this case, because this case was, judgment was delivered by the Honorable Justice Sarangi as a single judge. So therefore, you could not have heard this matter. So that is how it has come.
Right.
If my learned friend wants, then I'll give a copy of all judgments and also the listing. So let my learned friend verify that. If still he wants to argue, then I'll.
Yes, no, verify for this as you have.
So which is that order?
That order of division bench is.
No, but if any order was passed by a division bench
Yes,
of this court.
This one.
No, we cannot ignore that only on the ground that he was there in this.
No,
we cannot say that. We have our limitations.
Of course, my Lord Justice.
Yes, sir. No delay here.
No. That case.
That I have not seen that.
This Surama Mandir.
Yes. You also refer to that Surama case.
So it must be 200 or 300 days delay.
That I don't know. My.
So we.
Assume so far those matters have been dismissed on the ground of impetus.
This case there is no delay. This
Yes.
order is not.
So now what I am trying to impress your worships, even if that those writ appeals have been dismissed on the ground of delay.
There is no merger.
No question of merger. No question of merger. Once the judgment of the Honorable Single Judge has been upheld by the division bench, even if on the ground of limitation. So suppose on the question of merit, if your lordship will decide this matter otherwise, because this is a point to be decided, that will be inconsistency in the judgment. So far as those persons are concerned, the self-same ground, one judgment, so far the judgment of the single judge remain, and so far as this case is concerned, though that will be a different type of which will not is not permissible.
No, but those cases were decided mainly on the ground of delay.
Yes, sir. So those cases were
suppose one matter is decided on the ground of delay.
Right, sir.
And the similar matter which is not time barred.
Right.
Is decided on merits. The effect may be different.
My respect to submission is because one of such cases I have gone through that a substitution petition. suppose a person is dead, but no substitution was made or substitution petition was rejected. So far the judgment, judgment passed against that person, deceased person, remain as it is. So far the other persons are concerned, if the that judgment will be otherwise will be set aside, then that will be a conflict of decision. In that case, the Supreme Court has said that that is not permissible under law. Here is a case, what I am trying to impress yourself. If
So you suggest us that we should try to uphold that order.
Right, sir. On that ground alone. On that ground alone. Merger, Miller. I cannot go to that external. So perhaps this case also.
No, as we have understood, your submission is that suppose on similar grounds.
It is not a question of similar ground.
No.
The judgment which was the basis of the impugned judgment, that Nihar Ranjan case was the basis of the present judgment. That Nihar Ranjan case has been upheld by the division bench even on the ground of limitation. That is what I am trying to.
No, it has not been upheld by the.
Upheld means dismissed means that judgment of the.
Because the party was not allowed to assail that judgment because of delay.
But so far the judgment of the.
Even that Nihar Ranjan case is not also referred here. Here,
no.
Here we have referred Surama Manjari.
Right. Absolutely, Lordship is correct.
Which is just like certificate.
Your Lordship, on the ground of limitation, yes. You are dismissed.
SLP diary number has been.
Right.
Diary stage, it was dismissed.
But my humble submission is this Nihar Ranjan case was referred to in the impugned judgment while delivering the judgment. Now Nihar Ranjan case remain as it is. That is my submission. So for the merit of the case, I have not argued.
Learned single judge decision prevails now. As that's why they have challenged.
So far the government is concerned, government has implemented it. That is what. So far the if your Lordship will hear on the merit question of merit, I come because this is my duty to bring to your Lordship notice.
We will see. We will keep that aspect also in our. Yes.
May I please? Well, the order under challenge is at Annexure 3, page 129, mile. It starts from page 132, mile.
Yeah.
I will draw my lord's notice from paragraph 5 of that at page 141. May I read, my lord?
130, 141.
141, my lord. What question is involved in the present?
Is it a case that Mr. Rautray?
Yes.
Is it a case that Nihar Ranjan was one of the parties in the batch?
No. No.
He was.
It's already disposed of.
No, not batch.
No, it was already. So appeal has been filed. Appeal has been.
No, my lord.
Not in that batch.
My lord is asking that whether in that batch, he is not in that batch.
No.
No.
Now you see, page 132.
That is not Niharanjan's case.
You see, 132, second, Niharanjan Sarangi and others. WPC OSC 922 of 2016.
But another case, he has filed 1976. My learned senior is relying that judgment. That WPC OSC number 1976 of 2015.
So that creates some confusion.
Yes, perhaps she has filed two cases.
No, I don't know because somebody has appeared. Onno ke naam se nahi the, but that's it.
922 of 2016.
Sir.
Mr. J.K. Mishra was appearing. I don't know whether he is that same person.
A very short question involved in this case.
No, there must be two cases filed by Nihar
Yes,
Ranjan.
yes, my lord.
For the reason that the order which has been passed is in case of Nihar Ranjan Sarangi, and Nihar Ranjan Sarangi has been referred to in this order.
Yes, my lord.
Page 146.
Two cases,
Yes, yes.
one as untrained applicant,
Yes.
later on as a trained.
Yes.
The first
So,
one,
there are
my
two
knowledge
cases.
secretary is referring,
Same person and
same person as an applicant untrained. Later on, there was certain development and he has attended the training thereafter. In any count, the issues are same as my non-senior was referring.
So two cases. One is WPC OAC number 1976 of 2015. And the second case is OAC 922 of 2016. So these are two cases.
Two cases. Person is same. The earlier case was pertaining to untrained qualification, whether he will be
both
told
are before the tribunal.
Right.
So after tribunal got abolished, it has come this OAC.
And the distinct feature is that his application was in 2015 negative, and the challenge was he being the untrained candidate is also equally eligible. And thereafter certain changes took place. Trained candidates, those facts will merge in course of the hearing. In fact, they have not challenged independently this 922. This appeal is only.
The point for consideration is the advertisement was made. The last date of advertisement was a particular date, and subsequently a corrigendum was issued. Because of some overage candidate, they had approached the tribunal and tribunal allowed their application. And that they have acquired that qualification within the date of last date of corrigendum. The last date which was fixed in the corrigendum, these persons have acquired those qualifications within that date. So now the question is whether they are eligible or not. In another,
what was the cutoff date mentioned in the advertisement?
That is 22. I have prepared a date chart for Lordship, sir. 22/1/2000.
So by issuance of corrigendum, the date was not extended.
Date was extended. The last date of submission of the application was extended.
No, last date of qualification.
Yes.
No, last,
yes, that is
just this way. The last date of submission of the application was extended, and the qualification which was there in the advertisement that was there, you have to acquire this qualification before the last date.
Where is that? That is the crux.
Yes. That is the crux. And in another judgment.
No, where is the advertisement?
Yes, the advertisement is.
May I draw my lord's notice?
Mr. Rautra.
Yes, ma'am.
It is his appeal. Let him argue.
Yes.
Sorry,
yes, sir. Yes.
Sir, I am just assisting senior counsel. I have.
Yes, sir.
I'll point out my lord, 3 dates, my lord. 3 dates.
Yes.
Your lordship, turn to page 63. The annexure 1 is the first advertisement that is in Odia. So I am saying that only one date I am referring in that.
Page 63.
Page 63, my lord. This was the advertisement issued on 28/10/2014.
Last date is 20th November 2014.
20th November 2014.
20th of November.
My lord. 20th of November 2014.
This was what?
This was the last date for receiving application.
For receiving application. Where is the qualification?
I will come to that thereafter. Why I am saying 3 days, my lord? Later on, I'll come to that qualification part. Second, second correction was issued on 13/1/2015. The
First or second?
Second. First was last date was 2011/2014. Second correction was issued on 13.
This was by way of corrigendum 2011.
Original advertisement. Original advertisement was issued on 28/10/2014.
28/10/2014.
28/10/2014.
28/10/2014.
My lord, last date was 2011/2014.
Last date was 2011/2014.
My lord.
So in the original advertisement.
In the original advertisement.
Last date for submission of application was 2011/2014.
Right. Then my correction was issued on 13/1/2015. 13th January 2015.
So this is first corrigendum.
Yes, that is the first correction.
Yes.
The last date was 28/1/2015.
20th January 2015.
My lord.
Last date.
These two certain condition of that advertisement regarding that age fixation of upper age limit was challenged by some candidates before the Learned Tribunal. Learned Tribunal directed to relax their age. On the basis of direction of the Learned Tribunal, the third notification was issued. Your lordship, I will brought my lord's notice, page 66.
Yes.
Your lordship, may I read clause 4 of that?
Yes.
Earlier, the Director Secondary Education Odisha had published advertisement dated 23/10/2014 and 13/1/2000. Sorry, my lord, that I have said 28/1/28/10. That is 23/10, my lord. Sorry, my lord.
Yes.
Inviting applications for these posts. Subsequently, eligibility criteria and guidelines were also published in OPEPA website. Only those candidates who were eligible in all respect as per the eligibility criteria fixed in this advertisement and guideline published in OPEPA website and by last date of receipt of application. Receipt of fixed in these advertisement, but could not apply for having crossed as limit in the other can apply now. But this was extended till 22/1/2016.
Yes.
Keeping the eligibility criteria intact as per the last date submission. So only those who have crossed the age, they were allowed to apply till 22/1/2016 if they have the eligibility criteria as on the last date. That I was saying that last date was 28/1/2015.
exam.
28/15. Admitted that all these respondents have no requisite qualification as per the advertisement.
Where is the original advertisement?
Yes, ma'am. That your lordship may see that the resolution is at 27/10/2014. I have seen that original advertisement at on page 63, annexure 1, that is the Odia, my lord, that's, I could not. If your lordship permits, I can give that a translation copy.
Page 63 is the original advertisement.
Yes, my lord.
It's only one paragraph.
Yes, my lord, that there,
You
your lordship may
have
see.
stated that it is available in such and
That
such
is available in the
site,
OPEBA website, www.opeba.
Oh, no.
Yes.
We need to see this advertisement dated 23/10/2014. Full.
Then
Because
I'll-
every right will have to be.
Yes, my,
determined
sorry,
with
yes,
reference
yes,
to that advertisement.
yes, my lord, that because what has happened, my lord, they have filed that, I have annexed that read petition as annexure 1. I'll submit, your lordship may give me 3 days time.
No, that is required, brother. No. Very important.
Yes, I'll give my, your lordship may give me 7 days.
Advertisement is there on record.
That is on record.
Not advertisement, not on the record. Only resolution is on the record.
That is
If your lordship will look to page 68,
That is
subject to my learned friends.
that I am saying, that is the resolution. My
This is
lord,
the resolution, this is the advertising. There is no other, apart from this resolution, there is no other advertising.
that regarding vacancy position, everything in that.
This is the resolution where the
Vacancy
No,
position.
you are referring to which page?
page 68.
68.
Here also, if your lordship will look to, this is in English, kindly come to page 71, which has been interpreted in other judgment by the coordinate bench.
The Recruitment was issued on
27.
27/10/2014.
27/10.
Yes.
We have written 23/10.
That is wrong.
23, that we have mentioned it will be available from 28/10. Lordship, at page 63, your lordship may see, we have stated that it will be available in the web paper website from 28/10.
Is there any other resolution other than this 27/10/2014?
ସେଥିରେ ଯୋଉ vacancy ଟିକେ ଦେଖିଦିଅନ୍ତୁ advertisement ଯୋଉଟା ଆପଣ annexure କରିଛନ୍ତି ସେଥିରେ ହେଉଛି vacancy position।
ଖାଲି vacancy position।
ସେଟା vacancy that
ଦେଖ ଠିକ ଅଛି। And there is no recruitment rule. This is the procedure. Admittedly, there is no recruitment rule.
Procedure may be there.
Yes, sir.
But
This-
again,
Yes.
we want to see the advertisement inviting applications.
This is, sir, according to us, and they cannot dispute that this is the resolution.
yes, I'll find out.
Yes, sir.
Page 63 is that is in Odia, that is the advertisement for the local, all the public. They have referred to the website of the government. If I'll be allowed to read it slowly and thereafter I will give a translation on my own, my lord will understand.
only that portion says that it is available in the website.
Website and the vacancy.
My lord wants to see the entire terms of the.
Yes, what happened, that is a fact, that is a fact.
It was
What they would
available
say-
on the website.
Yes, what happened on 24/10/2014, they issued a resolution because there is no rule, recruitment rule. This is the resolution at page 68. Basing on that, my lord, this advertisement, this small Odia advertisement at page 63 was issued. Referring to that resolution, only thing further reference is there. So far the vacancy position is concerned, that is also available in the paper website. Only this is the difference. Or this Odia person, page 63 is the advertisement for the purpose of this particular selection. Therefore, in all the cases we have fought, this 2710, the 2410, this page 68 is the 2710 is the advertisement for the purpose of this selection. Though it is the resolution and guideline also.
Because it is in Odia.
That flows from that.
May I, Justice Raman, at least can you also look to page 68. What my non-friend says, page 68. This is dated 27/10/2014. Let's get it. Page 68, 27/10. Then kindly come to that Odia portion at page 63.
Yes.
That is the advertisement. ବିଦ୍ୟାଳୟ ଓ ଗଣଶିକ୍ଷା ବିଭାଗର ନିଷ୍ପତ୍ତି ଅନୁଯାୟୀ ରାଜ୍ୟର ବିଭିନ୍ନ ରାଜସ୍ୱ ଜିଲ୍ଲା ମାନଙ୍କର ଥିବା ସମସ୍ତ ସରକାରୀ ଉଚ୍ଚ ବିଦ୍ୟାଳୟ ମାନଙ୍କରେ ଖାଲି ଥିବା 5,634 5,634 ପଦବୀରେ ଚୁକ୍ତି ଭିତ୍ତିକ ଶିକ୍ଷକ ନିଯୁକ୍ତି ହେବେ। ଏହି ନିଯୁକ୍ତି ପ୍ରକ୍ରିୟା ସମ୍ପୃକ୍ତ ଜିଲ୍ଲା ଶିକ୍ଷା ଅଧିକାରୀଙ୍କ ଦ୍ୱାରା ସମ୍ପନ୍ନ ହେବ। ଆଗ୍ରହୀ ଯୋଗ୍ୟ ପ୍ରାର୍ଥୀ ଓ ପ୍ରାର୍ଥିନୀ ୱେପେପା ୱେବସାଇଟର ଜିଲ୍ଲାୱାରୀ ବିଭିନ୍ନ ବିଷୟରେ ଖାଲି ଥିବା ପଦବୀ ସଂଖ୍ୟା ଏବଂ ଅନ୍ୟାନ୍ୟ ତଥ୍ୟ 28/10/2000 ତାରିଖରୁ ପାଇପାରିବେ। This was on 27 or from 28th. This was published in the website of the authority.
Yes. This
That has been uploaded in the
My
website.
Lord Chief Justice, I'm just
translate also.
translated. So far this advertisement is concerned, this advertisement was made that that there are a vacancy of 5,634
in different government.
and this resolution was passed on 27/10. So therefore, from 28, the next date, from 28/10/2014, that all the this procedure and everything will be available in the paper website. That means this is this 27/10/2014.
Because everything was done online.
Online. So the basic,
There is no other advertisement.
there is no other advertisement. sir.
This is the process, man. They, my friend,
You have to
London
write
cannot
put the
produce
question,
it
what
also.
is the advertisement? In fact, this is the advertisement in Odia under Annexure 1 at page 63. The last date was 2011/2014, but that was on the basis of the guideline, that resolution dated 27/10/2014.
Okay.
Sir.
So do you agree that whatever rights flows to you because of any relaxation granted by the
Sir.
by the
Sir, my lord. State
by
administrative.
the state administrative tribunal is based on the reasoning assigned in that judgment, in the decision of the SAT.
Well, so far that judgment is concerned, rightly you also put the question, that was at the instance of large number of candidates, including the present respondent also. They had approached the tribunal because of the upper age limit, it was fixed to 38, because the previous year it was 42.
We are again putting the same question,
Sir,
that whatever reasoning has been assigned by the
tribunal.
For extending.
Yes, sir. Yes.
Age limit,
Yes,
and consequent extension of time for making of. the
Right, sir, right.
application, That logic will apply in your case also.
right, sir, right.
You are bound by
Absolutely, that cannot be done.
whatever
So only one addition, sir, there. That is so far as the training qualification is concerned.
We understand.
Sir, so far as the untrained, because we are going to press with your lordship that this resolution says even untrained candidate also can make application, but provided they will acquire this qualification, trained qualification, within 3 years from the date of their appointment.
That bracketed.
Right, sir, right. That has been interpreted. You have to write this.
Bold letter.
That has been interpreted in all those judgment. That means that's right. Kindly, sir, come to page 71. Yes, sir.
71.
Yes, sir.
71.
Yes. You also kindly come to page 70. Also come to page 70F. Hindi teacher. We are concerned with Hindi teacher. 3F. Hindi teacher. And if you also will come to page 71 to ensure that bold letter. The untrained candidates will have to undergo the required training within the timeline as prescribed by the government. This has been interpreted like those number of judgment by the coordinate bench, where it was said that it is untrained. That means even a person is untrained can make an application, and provided he has to acquire that qualification within a stipulated time has to be fixed by the government. You can also look to that judgment and also kindly see that judgment. Here and then serving. That was the judgment.
May I clarify that aspect? So let me complete my. It would be better. I will complete.
You wanted to bring the advertisement.
Yes, if your lordship permit, whatever has been uploaded in that website of paper, I will produce it by filing an affidavit to that extent. Yes, ma'am. Your lordship may fix it next week, any day. Your lordship may fix it.
Produced by Monday. Counsel for the considering nature of sure. It is desirable that the applicant produces the advertisement which, according to Annexure 1, was placed on the website.
Yes, well, uploaded in the web paper website.
Put it on the website and contained inter alia, contained comma inter alia, comma eligibility conditions in terms of age plus qualification, etc.
Well.
In this case, pilot is their intervention with some file number 2579. They are pending at.
Only one small prayer, Your Lordship. All the judgments provided by my learned senior kept on record.
Will be there.
Item 43.
We also have interest in deciding matters based on whatever is there on it.
My lord, your lordship,
We will not ignore it.
your lordship fixed it to Monday.
Monday.
Your lordship fixed it to Monday or Tuesday. 4th. But I'll file by weapon affidavit or by an affidavit.
File an affidavit.
File.
Now we can take.
So let them give it advance copy so that at least we'll have a response. Let them.
Yes, ma'am.
Item 43.
May I please the lordship?
My lord,
May I please the lordship, in this appeal,
my lord, I pray, my lord, this matter may can be taken up on next week.
Next week.
Next week.
Right?
Any
objection?
I will prepare. It is a read appeal. It is a read appeal, my lord. And I prefer 1 week time, my lord. Next week, Monday or
You are paying for a week's time because it is writ appeal. Yes, what is?
it is up to your lord.
Appears that he has some reason which he is unable to disclose.
Your lordship is accepting who am I to object. 1 week, make it.
On behalf of the respondent. Respondent.
Yes. Private respondents.
private respondent.
Item 44.
The state is the appellant minor, challenging the order of the non-single judge. Here, my lord, the issue with regard to refusal of approval for a 4th peon of a secondary, non-government secondary school. And the one single judge, past order, my lord, that is Annexure 1. The relevant page, my lord, page 27. Paragraph 10 held that in view of the law laid down by the apex court as well as this court, and as per the resolution passed by the government on the point in issue, the order dated 11/3/2013 passed by the district education officer in Annexure 8, cancelling approval of post held by the petitioner, cannot sustain.
Perhaps delay has not been condoned.
Then there is a noting, my lord, there is no delay, even though we have filed application for condonation delay because during the COVID
Application
time.
for delay has been filed, but that has not been dealt with.
No, already exempted. There was
And so far as the certified copy of the judgment, that has also not been filed.
Yes,
Yes. Well,
After
already
9 months,
delay
this
has
appeal has
already-
been filed.
When was the order passed?
My lord,
When was the order passed?
Order was passed
9/8/2021.
during COVID.
order was passed on 8/9/2021. And this was filed on 9/6/2022.
22 till May, Honorable Appeal Court,
That due to COVID.
10/1
Pandemic COVID
2022, their lordships have said 90 days from March, February last.
Consolidation of delay stands disposal. Yes.
And as per the High Court rules, but he is supposed to file the certified copy that he has not filed.
Here, my lord, the issue is, my lord, refusal of approval order has been set aside by the honorable single judge in the impugned judgment, that is Annexure 1. May I place the relevant paragraph of the impugned judgment? That is page 27, page para 10. Though, my lord, the issue is squarely covered by the judgment passed by the honorable apex court in the case of Rajendra Kumar Das case, my lord. But the honorable the single judge, para 10, while setting, it also kindly may permit to place, my lord. In view of the law laid down by the apex court as well as this court, and as per the resolution passed by the government on the point in issue, the order dated 11/3/2013 passed by the district education officer in Annexure 8, cancelling approval of post held by the petitioner cannot sustain in the IF law. Thereby, the said order is liable to quashed, and accordingly quashed. The matter is remitted back to the district education officer Baleswar with a direction to approve the appointment of the petitioner against the post of 4th peon as per the yardstick laid down in order dated 8/7/81, which was in force. And since the roll strength of the school was more than 100, the post of 4th peon against which the petitioner was appointed was justified as per the yardstick. The entire exercise shall be taken as expeditiously as possible, preferably within the 4 months. That is the direction. My first submission, my lord, the very fine observation of the single judge to approve the post of the petition against the 4th post peon. That is, my lord, contrary to the honorable apex court judgment in the case of Rajendra Kumar Das. Because in that case, my lord, the issue has already settled that there is no concept of the 4th peon in the yardstick.
Concept of
4th peon in the secondary high school in the yardstick. You'll also kindly see, my lord, only that. Only, my lord, that judgment will clarify everything. That is very issue, my lord, 4th peon. That is in 2003, volume 10, SCC, page 411. State of Odisha, that is also state as file of SLP, State of Odisha and others versus Rajendra Kumar Das. My lord, the relevant page, my lord, para 5. May I place, my lord? Para 5. In support of the appeal, the Lord Council for the State of Odisha submitted that the High Court missed to consider the several vital aspects. Firstly, there is no description of a 4th peon in the yardstick prescribed. The post of Daftari is a promotional post and it carries higher scale of pay. That being the position, the last entrant cannot claim the post of Daftari. For contrast, the Lord Council for the petitioner concern submitted that the High Court has considered the circulars and come to a right conclusion that the claim of the appointment as the 4th peon is legally enforceable. At this juncture, it is to be noted that at different point of time, the yardstick were formulated. The government of Odisha Education in so-and-so issued circular number so-and-so dated 8/7/81. That is the circular yardstick governing the field, fixing standard staff for the non-government secondary school. So far as the peon are concerned, the relevant portion in the circular read as follows. So kindly see, my lord, that only 3 posts of peon are admissible in the yardstick. One is office peon, second is office attendance, and the next is night watchman cum sweeper. That is only 3 peon. Next, my lord, clause C, it was mentioned where the roll strength of the school exceed 100, 1 post of Daftari is admissible. And admittedly, Daftari is a promotional post of class 4. Therefore, you also kindly see the concluding finding of the Honorable Apex Court, that is at 10. It is fairly accepted by the Law Council for the writ petitioner that the expression used in two circulars is daftari and not fourth peon. The High Court seems to have fallen in error by proceeding on the basis of as if the circular referred to fourth peon. This is clear from the reading of the various judgments impugn in this appeal. Next para. It is to be noted that post of daftari carries higher scale of pay and is a promotional post of class 4 employee. That being the position, the High Court was not justified in directing approval of the writ petitioner service as fourth peon, but one significant aspect cannot be lost sight of. If the school was entitled to have a daftari, certainly the appointment was to be made by promoting one of these three peons. Here, my lord, admittedly the appointment of the present respondent was made against the fourth peon. And therefore, my lord, in 2001, we have cancelled that approval order issued in favor of the respondent. By challenging that, my lord, the respondent filed a original application before the London OAT state.
The decision has been taken note of by the London Single.
But the decision is taken note of, but misinterpreting that judgment, my lord, held to approve the post against the fourth peon.
No, because London Single judge of finding because of the problem arising. As he could not have been appointed against the fourth post of peon after taking over, he was adjusted against second post.
But in the case of Rajendra Kumar Das, my lord, in that case, the Honorable Apex Court held unless and until the first among the three peon, one is to be promoted to the post of daftari.
Oh, please come to paragraph 6
of that judgment, my lord. Impugn judgment.
Yes,
my lord. My lord, in Rajendra Kumar Das mentioned supra, the Apex Court held post of daftari carries higher scale of pay is to be filled up by way of promotion amongst class 4 employee of the same institution. In para 9 and 10 of the shared judgment, it has been held if a school is entitled to have a daftari as per yardstick, letter 8781.
No, you already picked paragraph.
Para impugn order, para 6, my lord.
Interim order.
Impugn order,
Paragraph 6 in the instant case. In the instant. Case 23. Is that not the impugn order?
Oh, para 6 double.
All right.
In the instant case, admitted fact is that the petitioner was appointed by the managing committee against fourth post of peon in so-and-so school on 14/12/91. From the date he had been discharging his duty, his post was also duly approved by the competent authority. But after the school was taken over, the difficulty arose with regard to adjustment of petition against the fourth post. Thereby, he was adjusted against the second peon in SC Academy, Bograi. The inspector school, having found that the petitioner was adjusted there illegally, came to a conclusion that his appointment was void, invalid, and accordingly passed order on 25/6/2001, cancelling the approval order to the petitioner.
No, but after the school was taken over, the difficulty arose.
Yes.
With regard to adjustment of the petitioner, adjustment of the petitioner in fourth post.
Yes.
Thereby, he was adjusted against second post of peon in HC Academy, Bhogal, not in that school.
Yes, other school.
Other school.
Yes, but our case is, my lord, the very initial appointment of the present respondent against the fourth peon, that is also admitted by in the very appointment order itself. That is the petitioner enclosed in the writ petition. You'll also kindly see the appointment order itself, my lord. You also kindly see that very appointment order. Man, that is that. The initial appointment order is available on page 73. Also kindly have page 73.
Initially appointed, thereafter the senior must have gone to.
No, that is that is not the case in the present case. The senior most peon has not been till date has not been approved or promoted to the post of daftari.
Why?
Because the institution doesn't promote given promotion.
Why?
because at that point of time,
that is considered to be daftari post. But the senior one,
yes,
even though fourth peon is appointed,
yes,
by virtue of the this yardstick being achieved, the senior most will be daftari, and the fourth one will be third.
Yes, for that is my lord. I only play my lord one paragraph that Rajendra Kumar Das case, my lord. So,
Sir, you are a state of Odisha.
yes. That issue has all been decided. That is why my entire case.
Yes. But still you have one post of daftari. You have one post of
daftari.
You will not fill up that post.
That is not filled up by the government. But the institution is promote. An institution is a private one. That is the finding. Let's kindly see what the finding of the Rajendra Kumar Das.
Have you seen para 12
yes.
of this judgment?
Yes. Para 12. Let's kindly para 12 is the very finding. That is the main crux of it. The direction in the Rajendra Kumar. We therefore, while allowing these appeal, direct the management with private management. Management of the institution concerned shall move to the authority concerned for approval of the promotion appointment of class 4 employee as daftari. Because direction was issued to the management to promote.
Has given this verdict saying that you move the concerned authority to make the first one, the senior most man, as daftari. Then the fourth man can be adjusted as the third.
But my lord, in the present case,
simultaneously,
the word is there. Yes.
Simultaneously.
Let me place para 12.
Recommend for appointment of class.
Let me place para 12. With therefore,
class 4 employees.
While allowing these appeal, direct that the management of the institution, that is very important. Direction has been issued by the apex court to the management of the institution, and management is a private management. Two management concerns shall move to the authority. Authority means government authorities. For approval.
Your government.
Because unless and until management move and management send proposal by promoting that senior most peon to the
that has been taken over by That is a taken over school.
Taken over 94, but initial appointment 91.
Now he is under you.
Yes, now my school is taken over.
Your school is taken over. You have not filled up the post of daftari according to you. And because you have not filled up post of daftari, you want this man to go out. You have a welfare estate.
That is there. But unless and until senior man is promoted, because the direction is to the institution. And one more aspect. One more aspect. Let's kindly see the earlier way order, my lord. Let's kindly see. That is available by Annexure 4, page 38. Initially, my lord, against the cancellation of approval order, two of the petitioner, one the present respondent, another one Ashwini Kumar Raj, both filed the petition, original application, challenging
we will consider your submissions when appointment of senior
my only
of the department.
Yes. My only one submission.
Then surely we will consider.
My only one submission, my lord. Two original applications filed by the present one file.
By now he would have been retired.
Oh yes, already. By the time the honorable single judge delivered the judgment, he has already attended the
So you have exploited his services. Now
No,
you won't pay him.
He is no more in service since 98, my lord. 98 he is no more in service because we have cancelled the approval in 2001.
That is
And he challenged the order of the cancellation.
Correctly.
Tribunal set aside only on the ground that natural justice has not been followed, and he passed fresh order by following the procedure.
Just think of this situation that you did not follow the principles of natural justice while terminating a class 4 employee.
But subsequently it has been followed. Subsequently
you follow.
Again, cancellation order was passed.
Yes.
Sir, you can afford this luxury of fighting a litigation at every level. You can go to the High Court also. That you can afford. Because just think of this class 4. Legal bills are not fair.
Only one document, my lord. One document I show, my lord. Only one document.
No document. Not even a single one.
My lord.
That- 14. Yes.
Only one
45.
Only one submission, the law tribunal in the earlier way directed no work, no pay because he had not performed the duty. And here also he has attained the age of superannuation by the time the
prevented me
honorable
to
single
work.
judge.
He prevented me to work. The state prevented me to work.
Will not interfere with.
My lord.
others.
Yes, no, that's-
Item 45.
My lord, it is somehow. My lord was hearing, my lord was hearing item 42.
No, that is different.
That was segregated.
This case was segregated from that.
Let me complete. I am not saying similar. It is somewhat similar. I said, please hear me. Here, because in that case I was hearing my lord wanted to see the original advertisement. Here also, my lord, the advertisement is not there, but my lords have quoted it. So may I place it, ma'am? My lord,
Where?
may I take my lord? May I take my lord to the judgment, page 42? And my lord,
Page 42.
page 42 is the judgment. I will take my lord, I will invite my lord's attention. To page 56, please.
Yeah.
My lord, this is, the issue is here. If I, before my lord looks at the document, the issue is an advertisement and recruitment for a contractual Hindi teacher in 2014, my lord. Now, the admitted fact is, the petitioner came up before this honorable court saying, please declare my qualification as equivalent to the qualification in the advertisement. I'll take my lord to the prayer, admitted. And make me eligible and appoint me. Now, my lord, before I take my lord to the prayer of the petitioner, my lord.
No, what is the qualification?
My lord, that's exactly, my lord. Page 56. Hindi teacher. Bachelor's degree from a may I read it? I'm reading, my lord. Bachelor's degree from a recognized university with Hindi as one of the elective subject with minimum 50% marks in aggregate. 45%, my lord, I'm not concerned. Again,
No,
or.
no equivalence clause. There's no equivalence.
Yes, my lord. Now, my lord, may kindly come to the page. I'll take my lord straight away to the points I'm harping upon. My lord, may kindly come to page 44 now. The petitioner who belong, my lord, sir, page 40. The petitioner who belong to SCBC category and a graduate in arts in Rashtrabhasha Ratna from Rashtrabhasha Prachar Samiti Wardha and passed B.Ed with Hindi as one of the subject and medium of examination was Hindi, had applied for the post of contractual Hindi teacher pursuant to resolution, not necessary, my lord. Then my lord may kindly see the prayer. The prayer has also been quoted by my lords. Issue appropriate reads orders to quash the rejection of the petitioner's candidature to the post of contractual Hindi teacher as per Annexure 10. Then IA. Issue appropriate reads orders directions quashing the condition of having.
So she had B.Ed qualification?
She had B.Ed qualification from a university which is not provided in the advertisement. Now she says, because I have B.Ed and that is also recognized by NCT.
B.Ed from where?
Jammu Kashmir.
Not a recognized.
No, not in the advertisement. It may be recognized by the NCT.
Not recognized university.
Recognized by NCT, but not provided in the advertisement.
It is provided.
My lord, you have said
Hindi teacher bachelor's degree from a recognized university with Hindi. So B.Ed is a bachelor's degree
Yes, my lord, here,
from a recognized university. This is also fulfilled.
my lord,
With Hindi as one of the subjects. It is mentioned that she had Hindi.
my lord, looking at page 56.
Page 50.
My lord, the first is
Yes.
bachelor's degree from a recognized university with Hindi as one of the elective subjects.
Yes.
With,
Yes.
my lord. Now, with comes with Rashtrabhasha Ratna from Rashtrabhasha. First is or
Forget this. Or Ratna Bhasha.
my lord. Now, my lord, he comes under 1, 2, 3, 4 and the and. My lord will find and.
Yes.
After third or fourth or there is a and.
Yes.
And Hindi Shiksha Parangat from Kendriya Hindi Sansthan Agra.
No, but
BHED.
there is again the thing. Or an equivalent degree from a recognized institution. So equivalence is there.
No, it is not with regard to B.Ed. No, I am reading. And
No, don't read and. Or the last or is to be read with and.
bachelor's degree with Hindi as one of the optional honors subject with minimum 50% of marks in aggregate.
Last or, not last or, this first, second, third, fourth or is to be read with and.
With Snatak acquired by June 2005, the date up to which the temporary.
What is his qualification?
My lord, he has.
Whether he has B.Ed qualification or not.
BHED or B.Ed.
B.Ed.
What is her?
He doesn't have B.Ed qualification, ma'am.
B.Ed qualification.
Yes, ma'am.
What qualification does he have?
He has graduate in Rashtrabhasha Ratna.
From Rashtrabhasha Prachar Samiti.
My lord. And with he had obtained a B.Ed with Hindi.
First or, yes.
First.
With Rashtrabhasha Ratna.
So from which subject to that with that clause has to be.
Bachelor degree from recognized university with Hindi or Rashtrabhasha or Sastri or equivalent degree or. All right, we will see it tomorrow.
Man, I have given a, well, just before rising, my lord, let it be in my lord's mind. I have given a compilation, whatever I have filed in the compilation, I have given everything.
49 only day after tomorrow, lordship. Tomorrow I have some 49. Day after tomorrow. Day after tomorrow. Tomorrow I have some personal. Day after, lordship.
Item 52, my lord. Entry mode is still today, maybe extended. Entry mode is still today. Item 52, man.
Which matter?
Item 52, man.
52, let's just say on Wednesday.
No, tomorrow let it come tomorrow, my lord. I am.
Come there.
My lord, item 46. Entry mode can be extended. Item 46, the matter, my senior was saying that it has already been tagged up with a single matter to come along.
Yeah, my lord, this is the watchers. My lord, have kept that matter 29.
29, my lord, the item 46 be come along in the date 29th.
Lordship, item 58 is with respect to tenders in mines and minerals, your lordship. This is not assigned to this bench, your lordship.
58.
Yes, lordship.
Okay. This matter for appropriate page in terms of, yes.
Item 47, also directed to file the affidavit. Only one, I have prepared for 3, other 7 I have not prepared. I have to file by day after tomorrow, my lord.
Sir, item 47, then they have only evacuated a community belong to SC category. Only evacuated Pano community. One of the
47.
Yes, sorry, 57. Sorry, sir.
I guess.
47 is
My lord, may I be? Yesterday, I'm sorry, I'm disturbing your lordship. Yesterday, I had mentioned on my mention, your lordship acceded to the request and kept it the matter today. It is 56. Can it be any day shooting? Tomorrow or day after? Madam? Yeah. Yes, ma'am.